virtually today at 2 p.m. and they are saying the matter will be closed. It has been argued at length. So Lordship has finally heard it. My learned friend is there. If he agrees, then the inspector can appear virtually and then close the matter.
2 p.m. second, 2 p.m. 2 p.m.
2 p.m.
Not listed, my lord.
Not listed.
Not
Special
special
notice. Special notice.
It was date was indicated.
Yes, it was
Okay.
specific. Where to?
My lord, this is a appeal of 2003, 23. And due to conviction, the prisoner has been dismissed from service. He has filed an IA for early hearing. So I pray to the court.
Early hearing is always allowed. It will be included in including the weekly list and get ready.
My lord.
Whenever.
In fact, my learned friend, Mr. Pani, though he's not in this side, but he was in this side for at least more than 10 years.
24 years.
24 total as standing counsel.
So now let us see his color from the other side.
Save the courts, save the courts.
Get ready so that we can finish it up.
My lord.
Anytime. Yes.
But my lord, I am sure it will be very difficult to handle him.
It will be difficult to handle him for you people because he knows the trick of the trade from that side. Yes.
Not only that, prior to that, he was a state special public prosecutor, the cadre notes. So throughout notes.
So it is always a pleasure hearing such a.
Yes, it's vast experience, my lord. Right from the ground level.
We learn things from these kind of people only. I will have the privilege of hearing. Yes. Yes, MA, no mentioning.
Item 1. Item 1, my lord. On 10/7/2024, you received issued notice, my lord. The cancellation matter, my lord. Due to, my lord, the office, my lord, have to take some more time, my lord, required, my lord, for sending the. They have to, my lord.
Why cancellation?
My lord, cancellation, my lord, the anticipated will be granted by the Central Court, my lord. And direction was there, my lord, if the petitioner appear before the IO in the event of arrest, they shall be released on bail. But when they reach at the police station, along with the certificate copy of the order of the Central Court, my lord, they abuse the police persons and ransack the chair, everything, my lord. And thrown the the materials inside the police station, my lord. Thereafter, they went away. And without executing the, my lord, the order of the Central Court, my lord. Thereafter, on the way, they have again assaulted another police personnel of that outpost, my lord. For that reason, while this one granted bail, my lord, has not taken into consideration this 3 to 4 criminal antecedents against all the accused persons, my lord. But the question is whether they had availed that opportunity, not that is, my lord, in question.
Now you tell me one thing, if a particular court gives the bail in this court,
my lord.
And if you seek cancellation, is it not that it should go to the same court?
No, my lord, cancellation, my lord. My lord, that has been granted by the then, my lord, the court, my lord, the Honorable Justice says, not fair.
No, otherwise also is.
My lord,
The service is awaited. Oh.
No, my lord, it's notice, my lord, not, my lord, sir, the requisite has not been filed, sir.
Requisite you have not filed.
Since, my lord, government has to, my lord, obtain the instruction and it will go to the, my lord, account session, then only, my lord, they will.
Okay.
2 weeks, my lord.
Mr. Raghunath and counsel for the petitioner submits that due to some technical problem, the requisites could not be filed to serve the opposite party. He seeks 1 week, 1 week,
2 weeks.
2 weeks time. Least the matter after 2 weeks, yes.
Item 2.
Yes. Yes. Yes,
May
madam.
I please, Your Lordship?
Yes, yes.
This is a bail cancellation matter, Your Lordship. Your Lordship, the opposite party number 2 is not complying with the bail conditions, Your Lordship.
What are the bail conditions? Where is the bail order? Yes, I got it. Page 13.
Page 14, Your Lordship.
Indulge in himself, he shall. Which condition is not complying?
None of the condition he is complying with, Your Lordship.
No, don't make a sweeping.
One more FIR has also been filed against the opposite party.
He shall not indulge himself in any similar nature of offence? Has he involved in any case?
With this particular petitioner only, Your Lordship. One more FIR has also been filed because of.
After this bail
Yes, Your
order?
Lord. Yes, Your
Okay,
Lordship.
according to you, this is not compliant.
Yes,
Shall
Your-
appear before the trial court on each and every date. He is not appearing.
No, Your Lordship. As
Show
per
me
my
anything.
instruction, no, he is not appearing, Your Lordship.
Show me anything on record that he is not appearing. He shall not tamper with the prosecution evidence. Do you have any material?
Uh, I will ask for the material, Your Lordship. But as per my
Oh,
client's
you are asking for
instruction,
cancellation.
is not.
What I'll do is, I will just relegate you to the trial court and you move appropriate application. The conditions shall be varied. Okay.
Yes, Your
Right.
Lordship. Obliged.
Wide order dated 6/5/2022. The related head of additional sessions judge come special judge FTSC Baleshwar has admitted the opposite party number 2 on bail with various conditions. The petitioner has challenged has filed the present petition seeking cancellation of the concession of bail granted to the opposite party number 2 on the ground that the opposite party number 2 has violated all the conditions of bail imposed by the sessions judge by the order dated 6/5/2022. The London Council for the Petitioner seeks time to place on record the material to substantiate these case. I am of the considered view that if at all the opposite party number 2 has violated any condition, the petitioner shall approach the court below seeking variation of bail condition. Variation or modification of the bail condition. Accordingly, the present petition is disposed of, granting liberty to the petitioner to move appropriate application before the court below, seeking modification or verification of the bail conditions. If such application is moved, the same shall be considered on its own merit, depending upon the material placed before the court by the petitioner to substantiate the same. With this observation, the petition is disposed. Yes. Next.
My lord, may please your lordship, item 2, your lordship, my lord, opportunity of
If you want cancellation,
Dispose of.
no, my lord, opportunity of hearing may be given by the trial court.
obviously that I have said that. Don't worry. I have
Yes,
said
your lordship.
yes.
I can see.
Extension of time for surrender, my lord. My lord, extension of time for surrender, my lord. Order dated
It
9
was granted up till
No, order dated
June,
9
30th June.
My lord.
Why have you not
My
surrendered?
lord, due to sunstroke, my lord, it
Huh?
not due to sunstroke.
In the rainy season, sunstroke.
No, no, anything. Summer.
Where is the application? Sunstroke.
My lord.
What kind of? Then you pay a little cost again. How much cost you paid? You have not paid any cost. That's the reason you are seeking extension. Give 500 cost to the bar. Right off. The petitioner has moved an application seeking extension of time to surrender appear before the court below as directed by this court by order dated 9/5/2024. 24. The application for extension of time is allowed, subject to petitioner depositing rupees 5,000, actually rupees 500, 500 with the Bar Association, High Court Bar Association. So the petitioner is directed to surrender appear before the court below on or before 30th of 20th of August. 20th of August and avail remedy as per law. With this modification, the application is allowed and it is made clear that no further extension shall be granted to the petitioner in future. Yes.
Item 4.
Yes.
Modification of order, Lordship, pray for a waiver of para 9. So for depositing, Lordship, on the day of disposal, both parties were present. And the Lordship directed to the petitioners to pay 5,000 in court to the OP2. Accordingly, in court, OP2 taken 5,000 from the petitioner, and money received or prepared in court and submitted to the court, Lordship. But in the order that has been referred to that 5,000 each. So I pray for waiver of that
The petitioners are directed to pay 5,000 each
again.
to the petitioner. Number 2.
Opposite party to informant.
2 of you are there.
No, my lords.
How many?
Petitioners,
How many petitioners?
10 petitioners
10 petitioners.
again. हजूर कहले 5,000 टंका ताकू दियो बोली कोर्टे भी तांको दिया है
What was the offense?
ऑफेंस 3 SC/ST तो गणेश पूजा गंडगोल को नहीं साई पिलांग भीतर एटा दुई साई भीतर दैट हैज बीन कॉम्प्रोमाइज
Only 5,000. Why is
Again.
it 5,000?
Yes,
Because-
yes, ma'am.
Because each means 10 people.
50,000.
सेटा हे गला टू
10 जन अच्छा
असुविधा पिला बरा सब साई
Have you paid 5,000?
यस
Modified. Modified. The petitioner has moved the application and application for modification of the order dated 9/5/2024. This court has directed the petitioners to pay rupees 5,000 to the opposite party number 2. However, in para 9, instead of 5,000 to be paid by the petitioner, inadvertently 5,000 each has been mentioned. The same stands corrected. Yes.
oblige
Item 5. Yes, madam.
Should the case offense under section the appellant was convicted under section only 7 of the Prevention of Corruption Act. The when also the last occasion also directed to the heard the matter on the limitation ground. Substitution.
Substitution.
Let's see.
The sole appellant has died.
Died
When? And when you move
On-
the application? Come to your application, 1716.
on 10/8/2018.
10/8/2018.
18.
And you move the application on 11/7/2024.
Let's see.
So how many years? 18?
6
More than 6 years.
6
Huh?
years.
More than 6 years. Lordship, I'm having one judgment, Your Lordship.
Yes. So we-
On the ground of delay, in order to bring.
394.
Not 394 minutes, is also for bringing the LRs on record.
CPC
See.
parameters here, the parameter, order 22 you are talking about, order 22 rule 4.
Yes, my lords.
That
Rule
is
la-
a different parameter altogether.
And they have dealt, my lord, the delay part, Lordship, may kindly see, ma'am.
Which part?
My lords, given the wrong copy.
See, the consideration in order 22 is different. Here,
Better be on.
yes. Para?
That's- Page 698, para 32, my lords.
Yes. It must be kept in mind that whether a law is enacted by
Yes,
the
my lords. It must be
legislature-
kept in mind that whenever a law is enacted by the legislature, it is intended to be enforced in its proper perspective. It is an equally settled principle of law that the provision of a statute, including every word, have to be given full effect, keeping the legislative intent in mind in order to ensure that the projected object is achieved. In other words, no provisions can be treated to have been enacted purposelessly.
Hmm.
Furthermore, it is also a well-settled canon of interpretive jurisprudence that the court should not give such an interpretation to the provisions which could render the provision ineffective or odious. Once the legislature has enacted the provisions of Order 22 with particular reference to Tool 9, and the provisions of the Limitations Act are applied to the entertainment of such an application, All these provisions have to be given their true and correct meaning and must be applied whenever
Come to
called for.
para 34.
34.
Liberal
Liberal construction.
construction of expression sufficient
Liberal
cause
construction of the
is
expression
intended to
sufficient cause
advance the
is intended to advance
substantial
substantial justice, which itself presupposes no negligence or inaction
inaction.
on the part of applicant, to whom want of bona fide is imputable. There can be instances where the court should condone the delay. Equally, there would be cases where the court must exercise its discretion against the applicant for want of any of these ingredients, or where it does not reflect sufficient cause. The expression sufficient cause implies the presence of legal and adequate reasons. The word sufficient means adequate, enough, as much
That's
as.
the parameters. That's
parameters,
the settled
ma'am.
This
principle.
is not been applicable to my case, Lord.
No, no.
See, Bhagwan.
No, so
Sufficient
here-
cause is
already been
applicable.
died.
See, section 5 of the Limitation Act only says sufficient cause.
Yes.
So sufficient cause is there. But in the cases of this nature,
Conviction.
394, I'm wondering whether 394 can be rejected on the ground of limitation or not.
Because here the delay was only 778 days in this particular case, and it was rejected. ma'am.
Let us see.
Leave.
Let us see what are the cause you have.
Well, that's one more
Lordship,
paragraph I just want to place. Can we come to page 687? I will only read the placitum to make the
Right,
things
right.
clear, madam.
Yes.
Page
Right.
page 687, the placitum D, madam.
Yes.
Civil Procedure Code 1908.
Hmm.
The last paragraph of page 687.
687.
I'm referring the placitum. madam.
Placitum, huh? 87, right. Read.
D, last paragraph.
Yes.
Civil Procedure Code 1908, Order 22, Rule 3 and 9, read with Section 151, conduct of parties seeking condonation, relevant sufficient court, what is failure to bring on records, allows of appellant in appeal before Supreme Court for considerable period, delay of 778 days, applicant's ignorance of pendency of appeal, whether sufficient cause, held cumulative effect of conduct of applicant, clearly shows that they have acted with carelessness
Carelessness, irresponsible,
and did not state true facts in the applications. They had not approached court with clean hands.
That's again the sufficient reason. Let us see the application for
Ye-
condonation of delay.
yes.
What are the?
And was the only one, 2 lines from the below I will
Mm.
press. The sentence beginning with, they had not approached the court with clean hands, which itself a ground for rejection of such an application. Stand taken in one application contradicts stand in other application. Not even a whisper why applicants did not take any steps to inform their counsel about appellant's death and to bring LRs on record, except for vague averment that LRs were not aware of pendency of appeal before court. No other justifiable reason stated. This is the common ground that has been taken everywhere in every application. And the most interesting part, my lords, in most of the limitation applications, the delay of number of days are never been mentioned. Only they say the appellant has died on this day and there is a
In
delay.
your application, what do you say? The petitioner number 1 is the daughter-in-law of this is the appellant of the petitioner, the grandchildren of the deceased. They want to continue the
petition-
field and accordingly agree. That the
That's
sole
the
dependent died
petitioner is
from
the daughter-in-law
The application is seeking leave to
and the
continue
grandson.
the appeal to the appeal point of sanction. The petitioner could not know the criminal defeat on getting a letter from the advocate from where is the letter which has been written to you by the lawyer?
Letter has not been filed.
Then you say that I had no knowledge. I acquired knowledge when I received a letter from the lawyer on 25/6/2024.
That
Show me the letter.
that letter is
think-
not in record also. They have not
The
annexed it.
knowledge, if you are saying the knowledge is on this day, particular day, when you receive the letter, at least the letter should be there. You have not done. Because I want to pass an order as a test case by rejecting an application under section 5, under 394,
54.
by
Three-
giving a reason order. Because not that
Yes.
the appeals are pending and
For years
you come
together.
at
Yes,
your
it is
sweet
black.
wheel move an application at 394 and it goes on and on.
Lordship,
There
the
should
court can liberally the conviction matter.
A court can liberally do it, subject to condition that there is some fact available on the.
Bona
application.
fide fact.
There is nothing, then the court can't presume things and condone it. You have to give reasoning.
Yes.
Thereafter, a liberal view can be taken. If you don't give any reasoning, where is the question of giving
So valid and
merit
cogent
of
reason.
any particulars?
The Lordship, the last occasion, Lordship stated that the case is the merit.
Merit,
Merit is
that's why I
that-
said if you have a merit, if a chance of acquittal is there, then I will take a liberal view.
Yeah.
But I am testing the provisions of section 5 vis-a-vis 394.
Wow, 394.
390.
You do you have any judgment? If you
Let-
can, you
let-
render some assistance so that I can pass an order.
The letter.
You ask,
Lordship, the,
I'll keep on
but-
researching for you, then there is no point. How much I can research for you?
Lordship, the quality, 1 week.
Not 1
day
week.
after.
For research, it
Day
takes
after tomorrow, I will.
1 hour or 2 hour maximum. You can't research for.
No, no.
You are right, not writing a thesis.
Later.
Sit in front of computer, spend hour time, you will get the judgment. I'll put it tomorrow. Do it. Otherwise,
Day after-
I'll do myself.
Day after tomorrow.
Day after tomorrow. Otherwise, I'll do
The
myself.
case,
Keep this judgment.
Lordship, case is a very good case, only section 7, conviction. and
I am
only
not on
section
that,
7.
madam. I am not on that, madam. I am finding out a way in such application. Maybe you have a good case. I am not on that. But even if I condone the delay, I will write a judgment. So that will
Yes.
help the other people, you know. So therefore, I need little assistance.
Reference to the delay.
Those. So it's item 6, 7, and 8. We are awaiting instructions. Your Lordship may call this on 29 minutes. Other along with other.
Mr. Rijvi, let counsel for the, this is well-being and whereabouts.
Yes,
Yes, my lord, because we
You
have
have not
sent
asked for.
letters, but
29th, huh?
29.
29. Mr. Rijvi, let counsel for the petitioner submit that the instruction is awaited in this matter. Leave the matter on 29. Do you need any direction to the superintendent of police?
No, Madam,
Was there any direction already?
there must be a direction, madam.
Just
That
see.
is the noting has come that present status of applicant not yet received.
Yes, there is direction.
Yes,
Already there is direction.
Yes, madam.
All the 3 matters.
Yes, madam.
Millards, in item 7, there was already a direction, Millards.
Yes, yes.
Yes, all the matters. Yes. Yes,
6, 7, and 8.
9.
My lord, in 9, my lords, I have received, on behalf of Mr. Das, Senior Standing Counsel Vigilance, my lords.
You got any
Yes, he is alive, my lords.
alive?
Alive, and my lords, in the last occasion, your lordship has directed them to serve us a substitution petition copy that has not been served on us.
Anyway, list it in the weekly. We'll see. Yes.
Item 10.
Yes.
10.
Yes, sir.
What report has been come at flag X, your lordship may kindly class.
Report. Flag.
Flag X,
देखो flag.
notice was issued to the appellant as per your lordship's order dated 23/4/24, 23/4/2024. April 23rd.
देखो. कौन लिखा है देखो. निवेदन नहीं कीजिए ठीक होना. No, this next page, just see. Something is wrote in ODI. Chakri kori Bhubaneswar Visha Siba Tharun Prakash Payoru Karo Sakapano Library Open Karo Rokuru Long Karo Payoru Payo Karo Karo Nama Siba Service complete. Service complete.
Amicus curiae, your lordship.
Mr. Mishra, you help in this. Amicus curiae. The, by order dated, 8/3/2017, huh? No, 23/4/2024.
Draft.
Notice was issued to the appellant.
1.5.
Because Mr. Sarai, Lieutenant Counsel appearing for the petitioner, withdrew himself from the case. Service report placed on record indicate that the notice has been appropriately served on the appellant, but there is no appearance on his behalf. Therefore, Mr. Prasanna Kumar Mishra, who is present in the court, is appointed as an amicus curiae to assist the court. The registry is directed to supply the papers to Mr. Mishra.
As well as to me.
You are supposed to supply. You
No, paperwork is in the section, my lord.
supply to Mr. Mishra as well as Mr. Das during the course of the day. During the course of the day, lease the matter. When this matter is old matter?
15.
Lease
2015.
the matter next
It may
week.
be added in the weekly hearing list.
My amicus curiae means I will hear it like this.
Yes, hearing weekly list.
Then it will go in oblivion.
No, your lordship have already had so many matters appeal.
But
Judgment
you
is-
tell me when can you read? Get ready.
August 15th.
Huh?
15th of August for
No. Why unnecessary? Before that you talk about.
I have to go through the entire papers.
No, it's all right. He'll give it. Read it. Second, before you give a date. Huh? 7th. For you, it will not take much time. 7th. Read it.
7th, 9th, 12th.
In the, see, what happens is if I appoint a amicus curiae, if I keep it in the weekly list, it goes in oblivion and the amicus curiae is also forgotten. And thereafter, again, when the matter is taken up, neither the amicus curiae is there, nor the lawyer is there. We stand in the same position.
But my name also should be indicated in the cause
One
list.
Mrs. name reflect in the cause list. Get ready. Finish it up. Yes.
My lordship is submitting that on 14th.
12th. No?
12th is Monday. 14th.
12th, 13th.
13. Okay, 13. Okay. Yes.
Next matter.
Paperwork will be supplied.
Yes, I have given that.
Obliged.
During the course of the day, you collect.
Obliged.
Next matter is my
By
matter.
tomorrow, you not during the course of the day. The order will go by tomorrow. Yes.
Next is my matter, my lord.
Yes.
I am for the petitioner here.
Yes.
Difficulties, my lord, last whole week I was suffering from viral fever, my lord. I could not prepare a note of submission.
Okay.
This is-
Lease it next week.
Next week,
Mr. Mishra, then counsel for the petitioner submits that he is not keeping well. He is not keeping well, therefore seek an accommodation. Leave the matter next week. Yes.
I am applying for sub item.
Yes.
next week means, my lord, next week, Tuesday. Tuesday it will be.
Tuesday,
Last week.
1st August.
Tuesday ରେ ଆସି ହବନି ସେଥିରେ ଆଉ ଜଣେ ଅଛନ୍ତି ସେଟା କନସୋଲିଡେଟେଡ୍ କଜ୍ ଟାଇଟଲ ଦିଅନ୍ତୁ ଜଣେ 3 ଜଣ ଆକ୍ୟୁଜ
ହଁ।
1 କେସ୍ ଆବେଟେଡ୍ ଆଉ 2 ଜଣ ଅଛନ୍ତି 11 ତ ଆଇଟମ 11 ତ
No, abet करनी दे.
ଆବେଟ୍ କରିନି
In my case,
ଲର୍ଡସିପ କାଇଁ
in my
There were 3 matters. In one matter abated. So
Yes.
therefore, the cause title in your case is also required to be.
ଫାଇଲ
I have already filed the consolidated cost.
It's all right. No, abated then.
You are saying 2 persons have died, so 2 have.
2 ନୁହେଁ ଜଣେ କହିଲେ ଆପଣ
It's all-
ଶୁଣୁନାହାନ୍ତି
All right. We'll see. Yes.
May I please, your lordship. It is that 138 matter, your lordship may kindly recollect.
Yes.
Your lordship directed the petitioner should come with a draft of 70,000.
70. Has he come?
Yes, my lord, the petitioner is not here. My associate is there, my lord, I am producing.
Thank you. Thank you very much for persuading your client.
No, my lord, that is always there, my lord. I am always in favor of a settlement.
Pursuant to the order dated 19/7/2024, the petitioner,
And in fact, the microphone is possibly not nearer to your lordship, so we are unable to hear online.
Yes, the petitioner has furnished a bank draft bearing number so and so of rupees 70,000, which is handed over to the counsel for the opposite party. Yeah, opposite party. Take and record, photocopy of the in view of the said payment being made by the petitioner, the matter is settled. Therefore, the order of conviction recorded against the petitioner for the commission of alleged offence under section 138 NI Act is set aside, and petitioner is acquitted. Accordingly, impugn order dated so set aside, petitioner rejected.
Grateful, my lord.
Since
Thank you.
My learned friend appearing for the opposite party may receive it on behalf of the opposite party.
this matter was listed before Lok Adalat several times.
I know,
Now
but
because-
now because of the intervention of Mr. Mishra, it is done.
No, in fact, we are grateful to your lordship for getting this matter settled, my lord.
Otherwise, see, these 138 matters are clogging the courts unnecessarily.
In fact, ये मध्यस्थी थिला, he was not in fact the recipient of that amount, but मध्यस्थी हेले भी तो मरिवे तो न से settle करला ठीक अछि. He was telling me that he was not the person who received the money. ये मध्यस्थी थिला आउ जन लोग पैसा नहीं थिले. Anyway, but that has been settled.
Anyway, now it is settled then.
Now we are grateful, my lord.
Okay, thank you.
Obliged.
Yes. Next.
Item 13.
In item 13, on the last occasion, I had taken time to seek instructions from my client.
Regarding?
I have fortunately got instruction. My client is alive, and he has given me instruction that 80,000 was submitted before the court below, my lords. The check amount was to a tune of rupees 2 lakhs. And he is ready if your lordship would sympathetically consider a amount.
Who is appearing for?
My senior,
lord.
Mr. Mishra, is there for
My
the
lord, I am
opposition.
appearing for the opposite party in this case,
Mr.
complaint.
Mishra.
My lord.
80,000 rupees he has already paid. 2 lakh rupees check. He wants to pay. How much you want to pay?
Lordship,
Check amount at least you should pay.
Lordship,
Forget about the compensation. At least he is entitled.
well, it's
He fought the case since so many years. At least he is entitled to get his check amount.
My
That's
lord.
the only predicament what he told me, frankly, was that due to COVID and everything, his business has got
Maybe,
down.
I know.
And his house is also
Yes.
taken
yes,
away by the banks.
Mr. Mishra.
Surface.
My lord,
What do you suggest?
whether 80,000 has been deposited in the court below
Yes,
or
that
not.
is deposited in the court below. That was the
He-
condition there.
My lord,
While
he is
order dated
saying, so it
26
must have been deposited. Your lordship may direct it to be released. And rest of the amount, and 2 lakh, my learned brother is wrongly saying it is 1,75,847, which the court has directed to pay 2 lakhs.
2 lakhs. That
As
is
your
what I
lordship
was.
said. My prayer
Check
before your
was to
lordship.
the tune of 1,75,000.
My lord, my prayer before.
120 you give. I will give you 4 weeks time.
Well, it's another 1,20,000 apart from 80,000 that.
2 lakh
Yes, your lordship. Because it is 2009
But
matter, your
I'll
lordship.
give you. I will give you little more time.
Well, I will only submit one thing. If your lordship will keep it to
4
something
weeks, I
around
can-
another
you can
80,000.
negotiate. You can negotiate with me.
Another
so far as the time is
80,000,
concerned.
another 80,000, that is what my instructions
No, my lord, that
are.
is not possible
have
at all.
Check amount.
No,
175 is the check amount.
my lord.
80,000 already deposited.
After you being convicted by 2 courts in the revision, at least he is entitled to his check amount.
Yes, your lordship.
The only predicament is that he's not
Maybe
equal to.
predicament, but see, you tell me how much time you need.
Well, your
120.
lordship may grant me a week's time, then I.
Not weeks time. I'll give more.
Well, I'll just
You
seek
pay
instruction.
120. I'll dispose it up, and you pay 120 within 4 weeks. If you don't pay, then the sentence will revive.
That's what I'll submit, my lord. Just that your lordship may grant me 1 week's time. I'll take instruction. To
No instruction. I'll dispose it up. This
then your
instruction
lordship may
business,
kindly consider
I
at
just
least.
don't. Then I'll dismiss it.
Lord, your lordship may then consider 1
No.
lakh at least.
I'm giving you 4 weeks time, or you're talking about 1 week.
Well,
We are not. See, I'll tell you, we are not on the mercy of a convict.
my lord, I bow down.
Either you pay, or I will dismiss.
Well,
Very
that is
simple
what
as
I'm
that.
submitting, my lord. I have taken instruction.
Last time, see, the matter was reached
Yes,
on
sir.
16/10, 2023. Thereafter, 4.
Fortunately, I got reverted back from
Anyway,
him.
I'll pass the order, appropriate order. No? Very good then. I'll pass the order, appropriate. Don't worry.
But
In
that's
many
what
matters, I
I'm-
have disposed of in the same manner. I'll do it.
Then in that instance, your lordship may grant me 2 months' time. With
That's
equated
what I'm saying. 2 months I can understand. If you have financial difficulty, I can give you little more time. Pay
My
and
lord.
finish it up.
My lord.
Your lordship may grant 6 weeks time.
Let him bring the check here, Your Lordship, not allowing him to deposit and revive. Let him bring the check here,
I'll pass appropriate.
my lord.
80,000 rupees you have deposited, huh?
Yes, my lord.
Thank
That
you.
is pursuant to the order of this honorable court.
Pursuant to order, which order?
That is by order dated 26/9/2012. Once the revision was admitted, it was directed to deposit 80,000 to go on bail.
26?
9/2012, my lords.
26 pursuant to the order of this court dated 26. Where there is no order of 26. 9.
But it was the date where the notice
Yes,
was
no,
issued.
5/9/2012.
5/9.
Okay, I'll just do it. More than that, because it. This one, yes. Next.
Item 40.
Grateful.
Your Lordship will dispose of the matter, my lord.
Yes, yes.
My
I'll
lord.
pass the order.
Obliged, my lord.
Next.
Item
Well,
40.
Last occasion, your lordship directed the state council to take instruction from the IAC.
Yes, yes, that instruction came, my lord. The appellant regionally alive and is residing in his own house and suffering from old age sickness, my lord.
What is his age?
That Aniruddha Maji, my lord, aged about 65 years.
Weekly. He should be weekly.
Right.
Get ready. Yes. The person, person to the order dated Aniruddha Maji, na?
Yes, sir.
14, na?
14.
Pursuant to the order dated 12/7/2024, Mr. Mishra, the counsel for the state submits that he got the instruction from the IIT coding appears that the petitioner is alive and his whereabouts is also located. Therefore, the matters could be heard on its merits, at least in the details. Yes.
Obliged.
16.
What is this matter?
16.
15, he wants to say something. Item 15. What do you say?
Item 15.
What do you want?
Can't actually
You are for whom? Item 15?
No. On behalf of BK Mahanti, the
2 o'clock. Yes.
Make please allow.
Yes.
Lordship, the present petitioner has referred this revision against the conviction order, wherein he has been sentenced to undergo 2 years imprisonment for alleged offense under section 379 and 34, Lordship. Lordship, may kindly have a glance at the evidence, Lordship, in the LCR, Lordship, because there are many discrepancies in the LCR, Lordship.
Have you prepared a note?
Oh, no, Lordship. Yesterday only I got the paper book.
Okay. Then, when do you want?
Lordship may fix any day.
Yesterday, because I gave a direction
On 19th, Lordship, it was directed. It was a Friday, Lordship. That's why it was served yesterday only.
Mr. Mohanty, learned counsel for the learned amicus curiae, submits that he has received the paperwork yesterday and seeks a week's time to prepare the written submission and place before court, at least next week. Next week, Tuesday.
Yes, sir.
Get ready and come.
Yes, sir.
Finish
I have
it.
already prepared, Lordship, but I haven't prepared the written notes.
Written.
Okay.
Tuesday. Yes.
Item 17.
17, the noting is that instruction is not formal. Instruction from the ISC is not formal.
Yes, have you got any instruction from Baliguda, IIT Baliguda, regarding the well-being and whereabout of the petitioner? Not received. No, but it's all right. But have you sent it?
Yes, sir.
Huh?
Yes.
What was the reason not getting the info? Because this was an order in July, 11th July.
Actually, it's on 20th of July, it is over there.
11th July, I passed the order. Whether the IIC is not giving or from your office it has not
No,
gone.
from our office, yesterday night I asked for, he said only 2-3 days you give it because I have got it day before yesterday. So please
Friday.
give it to me.
Friday clear.
Yes, sir.
The order dated 11/7/2024 has not been complied. For compliance, leave the matter on. Yes.
Item 18.
Lordship, I am writing a letter to the petitioners. They have not instruction asini receive karinu. So they kindly take it on next. But
There are 11 petitioners here. Which police station?
hearing here.
See, the order was passed on 4th July. You didn't do anything. Within 1 week, what will you do?
Chithi diya hai instruction
Then we will keep on waiting for the letter to come.
next week. Yes.
Not next week. Tell me the police station. These matters are pending unnecessary. Tell me which police station?
Hearing here, please. District Hon'Ble.
Don't take it granted that you ask time, then it will be granted. Which police station you? Huh? All resident of Firingia. Police station Firingia. Is there any police station in Firingia?
Yes, Firingia district
Kandhamal. The IIC PS Firingia of district Kandhamal is directed to place on record the well-being and whereabouts of all the 11 accused within a week. Within a week. Leave the matter next Monday. Could week 29. 29. And make it sure that it goes.
Yes, yes.
Otherwise, I'll ask the IIC to appear in person.
Yes, yes.
Make it sure. Please, sir. Yes.
Item 19.
Yes. Yes. Nineteen. Password.
And 20.
Yes, madam.
May I please?
This is a case, my lord. I've got positive instruction notes and I expect my learned friends, clients, grievances will be mitigated. But prior to that, my lord, you can see the last order.
Yes.
For compliance with the orders, my lords, I filed an affidavit indicating whether the procedures laid down under section 102 CRP has been carried out or not. That I put it in positive word. But the real grievance of the petitioner is that certain in the DA case, my lord, the petitioner, his wife, and 2 daughters. Passbooks have been seized, my lords. In the meantime, my lords, on the affidavit you have stated that in the meantime, my lords, one locker number 195 of 2004 Union Bank Bhubaneswar was made operational, and the salary accounts of the petitioner was made operational. Now, Lordship, on the basis of my instruction, Lordship, record my submission, and Lordship, allow the defracing of all the accounts, because at the time of house search, date was 2nd June 2021, total 34 lakhs 4,726.88 was there on the date of the house search, my lords. Lordship, direct all the savings passbook, current passbooks of the petitioner, his wife, and 2 daughters, my lord, will be made operational, my lords. Defreezing, only keeping the amounts as on date of house search, my lords.
My lord, my humble submission, that is my prayer, my lord. My lord, the person is already retired. There is, since this case is pending, there is no pensionary benefits he is getting.
So my lord, there is no transaction. Already that is the amount already kept on hold. My lord, in that light, my lord, I have some decisions of your lordship. That amount can be defreezed. That is no. That is not a very.
No, who
Again.
is the main accused?
My lord, this present petitioner against whom?
Jayaprakash Manti.
Again.
What is the stage of the trial?
Stage,
Not started.
Huh?
Not started, my lord.
Charge and everything is framed.
Charge has not.
Charge not framed.
But
At this stage, how can it be released?
My lord, the allegation is.
let them get any benefits accrued in that all those accounts, my lord, which have been freezed, my lord. Only the money which
But
was
it says that everything will be defreezed. The only thing is the amount and the date of raid, whatever was existing, that you will not that will not be allowed to be withdrawn. That's
My
all.
lord, the
Not the
entire
data house
family
structure.
members' bank
And
accounts
my lord,
freeze
my
as
perception,
on
my lord, they
that
have
date.
opened up the salary accounts of the petitioner, my lord. He retired recently, but salary accounts was released, my lords.
Show me what judgment you are saying.
My lord.
Can I do it?
My lord.
A copy देखिए
Move it to the account.
Can I do it? Yes.
My lord. My lord, there is one of apex court judgment, another of several high courts, my lord. The first is that, my lord, I highlighted those parts for your lordship. My lord, that it is not possible to sustain the freezing of the bank accounts of the appellant taking recourse to the section 102 of the CRPC as the Prevention of Corruption Act is the act.
Special statute 102 is not employed.
So the bank accounts cannot.
Anyway, see, later can complete. Yes, this is one. Next.
My lord, the next is that, my lord, my lord, as per the Honorable Apex Court judgment in the court, state of Maharashtra versus Tapas Tinioji, my lord, that the such assets have direct link with the commission of the offense which the officer is investigating into. My lord, here in this case, the allegation that he is carrying a cash of rupees 18,80,000 and the FIR registered accordingly, and the allegation to that aspect till date they are not make any that these amounts are kept on by ill-got money or anything else. My lord, 30 years the person is working as a director in TDCC for 30 years. For entire family keeping such a amount, that is not impossible. My lord, 34 lakh, keeping 34 lakhs for 30 years of service, that is not impossible. That is not crores of amount are kept. And my lord, and 102, what 102 that they make an affidavit, they only stated that 102 is compliant. But what is the completely what the 102 particulars? My lord, immediately when they stated the magistrate, the date, there must be a forthwith, soon. That is the decision, my lord. Can we have a glance? I highlighted those parts. My lord, 102 state that the alleged or suspected to have been stolen or which may be found under circumstances which create suspicions of the commission of any offense. And the clause 3 shall forthwith report to the seizure to the magistrate having jurisdiction where the property seized is such that it cannot be conveniently transported to. In para 15, it is stated that 102 of the code of CRPC, police officer to seize certain property on existence of certain conditions which is prerequisites empowering the police officer to seize such property. He can seize any property, but the said property should have been property which may be alleged or suspected to have been stolen or which may be found under circumstances which create suspicion or commission of any offense. And my lord, in para 6, admittedly, it is not a case that property bank accounts is that is the case fact that the bank account is suspected for depositing or withdrawing or operating, transacting the stolen property. Therefore, it is necessary ingredient to empowering the investigation officer to seize the bank account of the petitioner are missing, and thus the seizure and freezing of the bank accounts of the petitioner is not sustainable.
Can you
My lord.
furnish any property security?
Indemnity bond, my lord.
Not property security.
Property,
Any property security if you can do, I will release it. This is how much?
34 lakhs.
34 lakhs.
My lord. My lord,
Tomorrow,
I will take instruction
you
in.
come take instruction. If you can furnish some property security, I will release the amount. Along with he is saying that the bank
Yes, my lord.
property security.
My,
Huh?
my.
Okay. Let out. Write down. The prisoner had challenged. That is what, yeah. Petitioner has challenged. What is happening? Petitioner has challenged the order dated. What kind of prayer you are writing, you people?
My lord.
Where is the impugn order? What kind of prayer? You don't write the impugn order date. You don't
My
write
lord.
anything.
My lord, impugn order dated, my lord, 21/11/22, which is in.
Page.
Page.
My. Annexure 2, page 10 to 20, my lord.
Next two.
My.
21/11/2022.
Petitioners have challenged the order dated 21/11/2022 passed by the District Initiation Judge cum Special Judge Vigilance Sundargarh in this case number 5 of 2022, whereby their application under section 457 CRPC has been turned down. The petitioner moved an application inter alia seeking release of how many bank accounts? Release of, where is their application? Where is the application? Release of various bank accounts which has been freezed by the investigating agency and in the direction to operate the same. Pursuant to the direction of this court dated 2/7/2024, Mr. Das has filed an affidavit inter alia stating agenda.
Compliance of section 102 CRPC for seizing.
Inter alia stating agenda para 3, 4 and 5. Mr. Das further contended that he has got a positive instruction from the department that the department has no issue releasing and defreezing all the accounts.
Enable the petition to operate.
All the accounts of the petitioners.
Wife and 2 daughters.
Petitioner, the petitioner accused, wife and his wife and daughters.
2 daughters.
2 daughters. However, Mr. Das submits that insofar as rupees 34 lakhs.
34 lakhs 4,726.
Which were treated as movable assets of the petitioner and his family, which was lying deposited in the which account? All the accounts.
In all the seized accounts.
All the accounts.
As on.
The same shall not be.
As on 2/6/2021.
As on 2/6/2020.
That is the date. That's the date of house search.
Shall not be allowed to be withdrawn by the petitioner and his family members. Petitioner and his family members. Mr. Swain, Mr. Swain learned counsel for the petitioner, relying upon various judgment of the Honorable Supreme Court as well as the High Court, various High Court submits that in the special, in the offences under the special statute like
Complete code.
Prevention of Corruption Act, the investigating agency can't freeze the bank account under the aid of the general provision contained under section 102 CRPC. She has particularly relied upon the judgment of the Supreme Court. Judgment of Supreme Court in the matter of Ratan Babulal Lal versus State of Karnataka in criminal appeal number 949 of 2021. 2021. I have taken into consideration the judgments, various judgments cited at the bar, and also the contention raised in the application under section 557 CRPC. Taking into consideration the fact of the present case, the judgment cited by the petitioner in the court, I'm inclined to allow the application with a direction to the investigating agency to instruct the respective banks to defreeze all the accounts and allow the petitioner and his family members to operate their respective accounts. That apart,
keeping intact the amount of 34.
No. That direction and property security. And that apart, I'm also inclined to give a direction to the investigating agency to release and the petitioner is also allowed to operate the account without any barriers subject to the petitioners and subject to the petitioner furnishing property security to the tune of 34 lakhs.
34 lakh, 4,000.
34 lakhs. It will be 34 lakhs. 35 lakhs. 35 lakhs. It will be furnished before the court below within 4 weeks. Within 4 weeks. Within 4 weeks. Accordingly, the application, according to the impugn order dated so is satisfied, and the application under section 457 CRPC is allowed with the aforementioned conditions. That's about you. Some of the field. Sorry,
Oh, please.
35 lakhs property security you give and operate.
Mine.
Yes.
Oh,
And Lordship, with regard, I'll arguing not point, but the judgment on which the reliance was placed, my lord, that pertains to attachment to the bank matters. Attachment provision under the Criminal Law Amendment Ordinance, Section 6. We are
your money is secured. Instead of immovable property, you are getting movable property.
I agree with that. But that because he relied the judgment is distinguishable because that particular judgment relating to attachment powers. Attachment power is available under Section 6 of the Criminal Law Amendment Ordinance. Now we are seizing.
I have not delivered anything.
Yeah,
I have only recorded it.
Only apprise you not. That's all.
Recorded it.
And
because see, the idea is the amount which is lying deposited, she can operate and use it, and your money is secured by property security.
We are taking it toward the assets of the petition.
Yes. Eventually, if you succeed in convicting, you can attach that property. Yes.
21.
Lordship, on the last occasion, the instruction was sought for from the Vigilance Council.
Yes.
Lordship.
Yeah, my lord is correct. Yes, the revision copy, lords, I could not get the case number. That register number was there. Now I'm supplied with this revision number, lords. That his grievance is pertinent to only one aspect, that GPF amount is withdrawn and deposited in a particular account. I'll come back to your lordship, lord, with
Release of fund, Lordship, for treatment of the petitioner number 1.
That is at page
Because
3,
it
Lords,
was
he has taken
withdrawn from the
ground that,
GPF amount.
the fixed
for
deposit
funds-
account was out of the GPF amount withdrawn by the fathers. That is the grievance, my lord. I'll come back to your lordship with the positive instruction. Lordship, give me some time. This case was on the record.
He needs for treatment.
Yes, Lordship.
So
I'll-
please do it urgently so that they can.
I'll get.
When do you want? Monday, Friday?
No, give me some time, Lord, because the other batch matters are coming. I'm preparing.
For
all-
instruction.
Yes, man. I definitely.
He needs it for treatment. If you delay it, what is the use of that money?
Treatment is not so serious, but he wants that I will see that it will be done.
Let it be Friday, you try. Let it be Friday, you try. If it doesn't happen, then we'll see. Friday. Awaiting instruction. 22.
22, Lordship, my plea, Lordship.
Yes.
Here, Lordship, is a case where the petitioners, they've been sentenced for simple imprisonment for 3 years and fine of rupees 5,000 each. The case is that these petitioners and other co-accused persons, they were employee of a certain bank, and the allegation is that they have misappropriated rupees 2 lakhs rupees, which was meant for some beneficiaries, loan beneficiaries. That is the basic allegation. And if you'll go by the
Prepare notes.
No, I was just going to the copy which was uploaded to me yesterday only. I was going to the judgment on this.
Prepare the notes so that I can.
I'll give
Tomorrow?
Let's see me grant.
When you. Because you are the MA query.
Coming week.
Huh?
Coming week.
The Land Council for the petitioner MA query appointed by this court submits that he prepare the written submission and address this court on.
So coming Tuesday.
Tuesday.
Yes, I will.
It won't take more than 10 minutes.
Of course.
Yes.
This short point is involved, can be disposed of. 23 also, Lordship. This is a simple case, Lordship. Here the sentence is 1 year with fine of rupees 1,000 for the allegations that the petitioner was carrying some railway properties with him. Admittedly, found from the judgment and all these things, the petitioner has no antecedents with him. No antecedent, absolutely. And this can be considered under PO, Lordship.
I could understand your indication.
That is the background of the case. No antecedent, absolutely.
PO for the correct. Thank you very much.
Grateful.
And I am passing an order for
Mr.
Allowed one.
Huh?
Allowed on display.
Mr. Mahapatra, on 19/7/2024, Mr. Rajesh Kumar Mahapatra, advocate, was appointed as the MIP security by this court to assist this court. The matter was heard at length. The court records its appreciation for the effective assistance rendered by Mr. Mahapatra as an MIP security. As a token of appreciation, the MIP security is therefore is entitled to a honorarium of 7,000 to be paid by the state. 24.
Good.
Matters are big losses. 24 matters are big losses. Part of matters had taken adjournment on the last occasion for filing a written submission. I have not been able to prepare. My sincere
What
apologies.
is this matter is about?
Matters, conviction under section 493 IPC, my lords. 2 years RI, my lords.
2 years.
My lords.
Then you have to. Do you think that is a case of acquittal?
My lords.
So what do you want?
So I pray.
Shall I put it in the weekly list so that you
My lords, I pray, my lords, it will be taken up next week. I'll prepare a
put it in the weekly list. Prepare and tell me immediately.
My
Lordship, I've been pardoned to make a submission, Lord, in item 20, Lord. Lordship pass the orders for property security. Lordship indicate subject to scrutiny, Lords, because sometimes
obviously, so that I'll pass. Subject to verification. Subject to
number of documents will be produced.
Indication is the subject to the
verification
scrutiny and verification by the
Genuineness of the property security.
Subject to genuineness of the scrutiny, verification and genuineness of the property security, property documents to be submitted by the petition. That I will do that. And that, see, that he has to, the trial court has to retain that original document.
Correct.
Original document has to be retained. I did not say that the procedure is that. They will retain the original document.
25.
Item 25, my lord, I am okay in this case, my lord. I am okay, my lord. But Mr. Fonda, advocate for the petition deliberately avoiding, my lord. It is an old case, your lords.
Who was appearing for the non-APS? Non-APS. It should pass over 138 after lunch. If nobody comes, then I'll dismiss. Yes.
26. Thirty-six, 506. Conviction under section 436 and 506. RI 2 years, fine 5 years.
I'll put it in the weekly, obviously. Weekly list, including the weekly list. Yes.
27, we have received the whereabouts. He is alive.
Alive?
Yes.
What is the offense?
The Prevention of Corruption Act, well, last occasion it was before, it was, and my lord was pleased to direct me to obtain, if there be any decision with regards to, in a case of Prevention of Corruption Act, whether application of PO Act will be there or not. But what I found, it's not there. No, only some judgments are there of the apex court that period undergone and some fine. Considering the duration of 10 years, 15 years,
Yes.
7 years.
What is the period undergone by this?
That is.
That was from the LCR, it can be made. From the LCR, that will
just take it up for period undergone. What is the sentence?
Sentence is 3 years.
That is 3 years on each account.
On each account. What?
Yes. 409 is also there.
51C, 52. And but I was
Section
calculating.
5 of
I was
this
calculating.
old act, my lords, and
I was
409 of
calculating the age would be around 80 years.
But he is alive.
80 years. And he is bedridden. I have also obtained instruction.
Written I just want to 3 years.
But I draw
what is
the
minimum sentence?
1 year. Minimum is 3 years.
Just see, check it out.
My lord, in fact, my lord, on the last occasion, I had drawn my lord's attention to some judgments of the apex court, but my lord was pleased to observe whether this can be done by a high court or not. In exercise, and I got a decision of Delhi High Court. It is
In
there,
appeal.
my lord.
In appeal. Can I do?
In appeal. Delhi Criminal Appeal number 30 and 31 of 78. Accused already undergone some part of sentence, conviction of harm, and sentence is reduced to period undergone. And in fact, they say, my lord, period undergone, my lord, in most of the cases, during that period, they were not arresting.
Yes.
Same day.
Same day.
Same day, my
they
lord.
are
Because I have.
So there is no undergone at all.
No undergone at all.
When I joined in the profession.
I know that. That was
there. Later on, the act became stringent and they used to take the accused to custody. One thing can be done that
80-year-old man, sending him to jail is very harsh.
that has
Very harsh.
been taken note of by the apex court also. And this Delhi High Court
Minimum
is also
1 year. Minimum is 1 year.
Delhi High Court is also by Honorable Justice Bhandari, Dalbir Bhandari. There also he said, some days he has undergone some period, no day, specific date has been.
Let us venture into the trial court record.
Right.
See if any sentence has to go on.
I could could not get it, my lord. Though I was trying to. Yes. ଦେଖୁଛନ୍ତି ପିରିୟଡ଼ ଅଣ୍ଡରଗ୍ରାଉଣ୍ଡ କିନ୍ତୁ ସେମିତି କିଛି ନଥିବ ସେମ୍ ଡେ ନାଇଁ ତ ନାଇଁ नहीं आपको ढेर लगे जजमेंट लॉ को क्लियर करिए ना जरूर सुप्रीम कोर्ट जजमेंट भगवान के बदल हाँ किया तो हाँ और लिखा है जो ऑनरेबल चाहूँ जो ऑफिस हो और पूरा कॉम्प्रोमाइज हो जाएगा के बाद ना पाओ अच्छा जाओ फिर संख्या दे दियो उसी कोई दियो विगत तो हो उसी कोई दियो और tail rising of the court
Was there any sanction, valid sanction? Yes, see sanction.
And I'll verify in detail on merit also. I don't want to argue
No,
this
you
case on
just
merit.
go to the genesis. If there is, if you can satisfy me, there is no sanction on the ground, I'll execute.
Sanction is there.
I'm
Because
setting
here there
find
is
out
no,
some problem in the sanction.
I think there will be no problem if he will be allowed to see.
You have to find out some problem so that on that ground I'll
because during
record an acquittal and leave it like that.
Nowhere I have found any decision that where it has been stated that yes, 1 month he was in custody or 10
That's what
days.
I'm wondering.
It's not there. It's not there. No, my lord. It is cited reported judgments also. It's not there. So, what I'm suggesting that he
No,
may be.
there is a proceeding that is 13/1/1988. It says accused to go on bail of 3,000 rupees with the surety.
Yes, but I have also seen that. I've got the printout.
Accused got the bail on that day. When he was taken into custody?
It's not there. 13/1/88 accused Justice so and so and other accused persons are absent. See PC advocate PC Hota advised Proclamation on behalf of Justice Vera and praised their petition to release the accused on bail. Copy served had the so and so accused to go on bail of rupees 3,000 with one security. Accused persons. That is with regards to other two accused persons, those who have been acquitted. Accused Kailash Chandra Muduli is present.
No.
Others accused person next bail are 22/2/88.
Yes.
Other accused persons are absent. Advocates for accused Justice Chandra Behra.
No, previous date he got the bail. That is 13/1/88 he got the bail. But I'm just searching when he was taken into custody. No, same day they appeared. Same day they got it. Because on 13/11/87, cognizance was taken, summons were issued. And on 9/12/1987, none appeared.
None appeared.
Next day on 13/1/88, they appeared and then they got the bail.
Same.
That was the practice.
Not undergone at all.
Yes.
During the practice everywhere in India, I think.
Yes.
Huh? And here, I think, my lord, on
Let us see that-
22/22/2088, accused Kailash Chandra Mudali.
What was the offense? Offense was?
My lord, with regards to, my lord, what he actually has been done, he was in charge of 16 coupe. Coupe in the sense, my lord, stockyards of forest. In one coupe, it was found that some timbers, those who were stuck there, that is found missing.
PCA told them, old PCA, yes.
वहाँ
1947
पे नहीं होगा. That Xerox copy. हाँ.
That the present appellant was in charge, and it is alleged that he handed over the charge to PW4, but PW4 says, I have not received this stack in question. And out of that, some witnesses have also deposed to the effect though it has been shown in the logbook that it has been trees has been caught, but in fact it was not caught. And it has been mentioned in the logbook that it has been caught, and the logs have been stored. And the document while the present appellant has shown the letter of dated 2841, letter number so and so, dated 10/4/68, which is a circular of Orissa Forest Corporation, that it is not his duty to take care of everything, because he was the supervisor. Again, under him, additional supervisor was there, but he has been acquitted. Other two persons, Chetty Satyanarayan and Jyotish Chandra Behera, they have been acquitted. Even, my lord, I was going through.
How many accused? There are 3 accused, huh?
3.
Then what happened out to 3 accused?
Other two, my lord, even they were not put for 313. So before recording of 313 statement, they have been acquitted.
Then only Kailash remained.
Only Kailash.
I'll do TRC when finish it up. Because see, I'll just read the provision. Old Act 5.
Yes,
it says that any public servant who commits the criminal misconduct shall be punishable with an imprisonment for a term which shall be less than 1 year, not less than 1 year, which may extend to 7 years.
7 years.
And shall be liable to fine also.
Yes.
Provided that the court may, for any special reason, recorded in writing, impose a sentence of imprisonment less than 1 year.
Well,
less than 1 year means even 1 day also.
1 day also.
I will employ this and 80-year-old man and
no,
yes. What do you say?
Yes.
This you can't send him to jail like this. इसको करके दे देना. TRC करके छोड़ दे. He'll try you. His sentence will be over after 10 minutes, huh? Because I am rising. Today I will pronounce, whenever I will pronounce, that day will be treated as the rising of the court. Not today.
Yes.
The day when I pronounce the judgment, that day when the court rises, this sentence is complete. Okay. Yes. TRC, yeah? Take the TRC. 28.
Judgment reserve matters. Judgment reserve matters.
Judgment reserve.
Yeah.
The day I pronounce it, on that day the sentence will be complete.
Right.
28.
28 mallards, we have taken another attempt in order to ascertain the whereabouts. Mallards, but we failed mallards.
29. Then I'll keep it on 29.
My lord, this is the second attempt we have taken. Earlier also we have taken an attempt. This is the second attempt we took on 27. Still, my lords, nobody was able to tell anything about the appellant.
Then what to do in these kind of cases? I can't presume that he has died.
My lords.
It
I
can't,
also, no.
see,
This
something
is-
has to be done. If petitioner says, I don't know, and you are the prosecutor, you are supposed to know.
My lords, we are doing all due diligence, but we are not able to trace him. Third time we have taken attempts. 3 attempts we have taken.
I think this is the same for the one.
Simply which was-
Well, we pass the same order ballot that yeah, see what a case, or a case. The ASB say to.
Take
And
notification.
that too, he will not get any benefit if conviction will be there. कितने ऑफर करियो तुम?
See, then there is no end, na?
My lords.
No end to it.
Somebody, see, I'll tell you, it is the prosecutor. Suppose the counsel is appearing, he'll say that I'll not appear. He goes.
My lords.
You are the
Yes.
you are prosecuting
My
him.
lords, I understand.
You have to find out.
What age कहते हो?
ये लखे accused statement भी नहीं है जो about dash years लखे.
89.
What was this?
Age is not there.
Actually, kindly see the charge sheet in the LCR. my
Okay.
lords.
28 na item.
Item 28 months.
Okay.
ऐसे मैटर में he's Sindri Ramarao.
Yeah, Ramakrishna Rao. Yes.
Ramakrishna Rao. Junior engineer, 44 years. In the year 1987. 89.
What is your
44.
Count now. 44 years.
19, my lords.
1989 is the charge sheet. I am looking at the charge sheet.
44 years.
79 years.
80 years.
Near about 80 years.
80. 87. 87.
Hmm?
87. No, I don't.
No. 80 years.
80?
In 2024.
Hmm.
87. 80.
80.
80 years.
70.
79 plus.
41 May 47. 81 May 87.
Offense?
Yes.
Conviction is for what?
Same manner. 5-1C read with 5-2 of the office.
RI for what? 1 year. Man.
RI for 1 year. Minimum sentence has been given with a fine of 1,000.
उसको भी ऐसे करते हैं.
Same कर.
Same.
TRC करते हैं.
Yes.
Then तो खत्म ही नहीं होगा. Then there is no end to it.
Yes, ma'am.
For TRC.
नहीं पैडल नहीं लड़ो
ये दोनों दे देना करो.
नहीं पैडल नहीं लड़ो आइटम 26 टा आब्सेंट हो गला 8 जन हो जाई ता आसु 26 तारिख खाली डिसीजन टा दवा में थिला
एडजन है कि केबे जे है कि जब करियो.
सर वीकली लिस्ट ले और सप्लीमेंट
You mention it tomorrow.
टुमारो आसु
Tomorrow you mention it, we'll see. Yes.
आज आइटम 26 थिला मैडम
That's right. If you don't come, what to do, sir?
नहीं आसु दिल के लेट है
We'll see.
प्रॉब्लम है
We'll see. Yes.
टुमारो नॉट टेक अप
Tomorrow you mention, we'll see. Yes.
59, let's say the sole appellant has died and I have filed a IA for substitution, died on 28/11/2023. Filed dated 17/1/2024, so 19 days, 19 is the delay.
19 days.
19 days.
So delay कर दो. 389 application allowed. The sole appellant has died, and the applicant, being the wife, being
Yes,
the wife of the
widow.
sole appellant, she seeks the permission of this court to continue with the appeal. For the reasons stated in the application, the same is allowed. And so
Consolidated cost
action to be filed within a week. Lease the matter in the week. Yes.
30.
Presentation of corruption act lots conviction are 13-2, already 13-1 and 13-2 lots. 13-2
2 ready 31 Lordship, RA for 3 years and fine of 10,000 rupees. And under section 7 Lordship, RA for 2 years and fine of rupees 5,000 rupees Lordship.
Have you prepared the kind of written submission or anything of that sort?
Lordship.
Prepare it weekly. Weekly. Yes. Get ready.
Lordship.
Don't be yes.
31. That is the draft case. He has been convicted on section 13(1)(d) and sentenced to undergo RI for 2 years. Your Lordship, that is where in the preparation of written note of argument. I will prepare the written note of argument.
Yes.
Weekly matters.
Weekly?
Weekly, yes.
Please do that so that we can finish the weekly. Yes.
32.
Lordship. Item 30 next week, Lordship. Item 30.
It goes to weekly list. Get ready. Next week. Yes.
32.
32. Very old matter. Non-ABS for the petitioner. At least the matter is weekly. Weekly. Yes.
33.
Item 33, my lord, I filed my vakalat now, my lord, but it has not been reflected in the cause list, my lord.
Mr. Mishra, learned counsel for the petitioner submits that he has entered appearance for the appellant and filed the vakalatnama. His name is not reflected in the cause list. The same may reflect and lease the matter in the weekly to
Yes, weekly projected I could actually
20?
20.
22 weekly.
Yes,
Yes.
Maybe taken next week. 30 of the
Yes. What do you want?
I have your time, my lord. I have taken
Let it go to weekly list.
Next week.
Yes.
August.
Weekly list. Yes. Yes.
I beg your lordship's pardon. I was on item 32, but I could not appear in time, your lordship, for which non-appearance has been noted. My non-appearance may be kindly
32. What had happened? Weekly.
My non-appearance.
Appearance. Appearance.
Grateful.
Yes. Yes. Special notice. Special notice. Okay. Yes. What had happened in this?
Thank you. Thank you.
Yes, yes, that main accused, what have you done?
Sir, my lord, we have obtained CDR of the parents of the warranty. We have also obtained the warrant, but he is absconding since 2009. He is not coming to his house since then.
Absconding in 2009 doesn't mean that he has left the entire world. 2009 and what have you done? Because see, these people are unnecessarily, suffering this. Main accused is enjoying. And you have not taken, what are the steps you have taken? Give in writing. Let us see. What step you have taken? Not making a simple statement that we have made the efforts. What are the steps you have taken? How many attempts you have made to raid or whatever you have done? What have you done, by the way?
Actually, it was not with his knowledge that the warrant was issued against the present case. After this case was filed,
Let's see.
notice was issued. Then after he queried, then the CTR was called for, and on query, then he found that since
He has been the IO throughout, right from there. The earlier IO has not done anything.
4 months he is taking charge last.
And within these 4 months, when you came to know about this case, after this court issued notice to you?
Oh, my lord, during election time when I was trying to execute the warrant, I found that that person is not in the locality and absent since 2009.
No, if you leisurely go and ask in the his house, then obviously he will be absconding. What step? You have to take some step,
I have obtained
tangible
the-
step, no, to arrest him. How much time will you take to arrest? Because why these people will be stuck in this?
His house is just in the front of the police station.
Their family is there.
Old parents.
Huh?
Old parents.
Then how do you expect that? How do you think that he will not be coming? He must be coming there.
I have obtained the CDR of the parents of the accused person. He is not also contacting them. Last 6 months.
No. You have to do something. I'm giving you 1 week time. You arrested. Tell me. I will not pass any order, but you do it. And insofar as this case is concerned, I have to deal with in accordance with law. Main accused has to be arrested. Main accused has to be arrested. What
He
you?
has caused everything he has caused. Because from record.
Everything A to Z he has fought.
A to Z.
That vehicle was sold to Suchesmita.
He has not cheated him. He cheated the bank. He cheated RTO. He cheated the earlier the complainant, Suchesmita.
And subsequently he get double benefit. Because finance was made by the ICICI Bank, 8 lakh something was finance. Then he sold that to Suchesmita. Suchesmita.
From there also he has taken.
तारा 18 लाख नहीं गया 16
Then 8 lakhs was taken from the Suchesmita. So double benefit he gets.
गाड़ी रो दाम 8
And
लाख
manipulated everything in RTO, and they are victim now because of RTO, because he applied for loan to Tata Finance, and Tata Finance verified by RTO, everything is all right. It was sold to him.
And I was surprising that no record is found in the RTO office.
That-
RTO was giving statement in that case matter, it was filed, appeal case before the collector. RTO has stated there is no such document in our office.
गाड़ी रो दाम 8 लाख ये नहीं गया 16
And he's staying in front of police station, and police says that we are not able to arrest him.
nearest to church is farthest from God.
Rightly applicable.
Parents also stated that he is not communicating, or he is not contacting us, he is not
There,
communicating.
there must be some, I tell you, there must be some underlining thing.
And he has been cheated.
Not that it's not, don't make it so simple.
He has also cheated many people.
The police knows very easy.
And also.
He's rightly chosen the place to stay in front of police to get right protection. You arrest him within 1 week. I don't know what will you do. And you know, if you want, you can do it. If you don't want, you can't do it. This FIR was registered in 2009.
Nine.
Today we are in 2024. When a charge sheet is filed,
Yes, sir.
charge sheet is filed, showing him absconding. Absconder.
It was submitted on 22/9/2007.
Yes. Who is this Susant Parija?
He
Pujari.
petitioner. I am the petitioner. I have been cheated.
You are also shown absconder. Devi Prasad is absconder. Ashok Das. No, he was You have given a written note, no?
I'll
Give a written note.
I'll give a short written. By tomorrow I'll.
Part heard. Mr. Sonpo appears pursuant to the direction of this court dated dated 16/7/2024. What is your name? Sasikant? Sasikant Raut, IIC, Airfield Police Station, Bhubaneswar, is appearing in person and assures the court that the necessary steps will be taken within a week to make sure that the main accused is arrested in the present case. 1 week time I am giving you. and you don't come, appear in the VC and tell me after 1 week what have you done. Put it on the next Tuesday. And meanwhile, Mr. Palit would be filing a short written submission.
By tomorrow,
By tomorrow, you give it, I'll pass the order.
Right.
And Tuesday, VC you appear.
Great.
And tell me within 1 week what you've done. And show me some paper what step has been taken. Nothing. From the record, show me what step the police has taken to arrest this man. Do you have any paper with you? The NBW issue is neither here nor there. What step have you taken to arrest the accused? Merely issuing NBW, not executing. What is the meaning of it? You track his mobile number, you track, there are many ways to do it. I can't advise, you are a better person to know how to do it. Make efforts. Make efforts. Within 1 week, you can make a lot of efforts. And let us see next Tuesday what efforts you have taken within this week. Tuesday.
Great.
I will not give further time, I must tell you. 2009 FIR, you can't leave a matter like this for such a long time. And since you have taken over since last 4 months, I am giving that liberty. Try and do it. Try and do it and tell me on next Tuesday. If you need further time, I'll give you, don't worry. But try within this week, let us see what efforts you are taking.
Great.
Next Tuesday, you come and say that you appear in VC. Don't come here. Don't waste your time. Come and tell in the VC, this is the steps I have taken, but I could not arrest or I could arrest, whatever. Then we'll see, because I am dealing with this matter. I'm not interested in anything else. I have to pass this order. He is giving written submission, I'll pass this order. But I want that man should be arrested. He has cheated many people.
Great.
Yes.
Item 25. Item 25.
Morning, what will we call that?
Oh, 20?
25. Morning, my lord, they have also
Then
absent.
I'll simply dismiss it. Huh? 25. Non-APS for non-APS for the petitioner. Non-APS. Earlier also nobody appeared. First time it is listed. After 2016. Simply non-appears for the petitioner. Dismissed for non-appearance. We'll see.
Item 15.
Don't appear for opposite party. Yes, 15.
Please, Your Lordship. Here I am for the petitioner, my lord. I have filed a miscase for amendment of the prior portion. Wrongly, the petitioner has not stated to quash the order of the Law and Trial Court. He has only stated to quash the order of the appellate court, my lord.
Okay, it's all right. Okay. Come to the point.
Yes, my lord. Here, demand notice has not been issued in this case. Demand notice has not been issued, my lord.
Achha, 138 case.
138.
Why there are 2 appeals?
Under the
revisions?
The other revision we have filed for inadequate sentence. Inadequate sentence because enhancement of sentence, because my lord, the Lawrence, while the check amount is 8,50,000, the Lawrence Sessions Judge gave a finding that the accused has no capacity, so he has to pay 3 lakhs rupees. And the check amount covered is 8,50,000. And the sentence was
show me the finding that the statutory notice was not given. Where is the finding to that effect? And show me the complaint first.
Another one point is that, my lord, another is the company is not made a party. Yeah. And also the notice was issued to the joint venture, not the, neither the company nor the.
You say that notice was not issued.
No, issued to the joint venture company, not to the company or to the director of.
Show me the complaint.
Yes, my lord.
Where is the complaint?
The PW1, the complainant, in the cross-examination in paragraph 8, he has stated that the MU was signed with Purushottam Engineering Private Limited. That is a company. And another company is also there. There is a joint venture. In paragraph, my lord.
Where? Paragraph of what?
The cross-examination. Cross-examination. Yes.
Where is that? You have to give me.
LCR, in the LCR.
Huh?
It is in the LCR. It is not with me, my lord.
Where from you read then?
Xerox copy.
LCR is not there. Where from you got? Here is not there. You have the copy, give it to me. The photocopy which you have, you give me. You have 2 points. One is statutory notice under 138 NI Act is not given to the accused.
Either accused or to the company.
Or to the company, rather it was given to a joint venture.
Joint venture company.
Which is a third company.
In a different address. That is
it is a third company.
Miller.
Okay. Next point is the company is not
Company
paid
is not made a party.
Rather the check was issued by the company.
By the company.
Yes.
Yes. Your Lordship, may kindly say the pleader's notice was issued to the joint venture company, not to the company of the director. सेटा मध्ये पठेइछन आईओसीएल एड्रेस रे आमे काम छाड़ देछु 2006 रे 2007 रे आईओसीएल को पठेइछन.
You are the director of Purushottam.
Purushottam.
Both, my lord, both.
No.
For both the companies, is that?
No, both. He has admitted in the cross-examination that he knows the address of Purushottam Engineering and also the accused.
How will you get over this?
Your Lordship, may kindly see my learned friend, to suit his purposes, he has highlighted his part. Your Lordship.
No, see the notice he has shown it to me. You have issued the notice. I forgot about joint venture and all. You have issued notice to the director Purushottam. Issued notice to the director Purushottam. Whereas you are prosecuting Saroj Kumar Pusti.
My lord, your Lordship, may kindly see the address given. Saroj Kumar Pusti.
Who is Saroj Kumar Pusti?
Saroj Kumar Pusti is the director. He is the.
Where is the company?
Your Lordship, may kindly see the cause title of the case as well as the notice. It has been described in the judgment. Your Lordship, may kindly see.
But you have not made specifically the company as a party.
Your Lordship, may kindly see. I may be excused. Your Lordship, may kindly see. He has been described as director, Messrs. Purushottam Engineers Limited, Private Limited, and United Construction Private Limited, joint venture. Head office at OSL Tower, Link Road, Cuttack, Odisha. Camp office at IOCL Refinery Project, Paradip at District Jagatsinghpur. My lord, company represented through Saroj Kumar Pusti and Saroj Kumar Pusti represented as director. That has been described. So, your Lordship, no way prejudice has been caused to the accused.
But you have mixed everything in one cause title.
Your Lordship, may kindly see why that has been done. With due respect, your Lordship, the documents which has been executed, your Lordship, may kindly see what has happened. This complainant is a contractor. And the accused, your lordship, is a chartered accountant, is also the director of two companies, and he was exercising some business at Paradip amounting to 600 and 700 crores from a different dredging company. He was engaged in port area, acquired 1400 acres of area, and was engaged in dredging material. So for the purpose of some construction, your lordship, he had no money. I am a contractor. He requested me to lend him some money. I had also no money. I took loan from different banks and helped him. And by way of giving drafts to the seller, that means, your lordship, the company which the shopkeepers who were supplying materials to the accused, cement, chips, all these materials. For all those materials, your lordship, I had made payments by way of drafts. On the day of paying drafts, he used to give me a check as evident the draft by giving 30 days time. And in view of the contract, your lordship, I was going on supplying materials, and I have got 25 lakhs. Still 28 lakhs, 29 lakhs some odd, amounting to 30 lakhs has remained still unpaid. And this accused, your lordship, my qualification is I am a simple matriculator doing some business, and he is a chartered accountant involved in crores of business of crores of rupees, and also his antecedent is that he has been convicted in some similar cases, and I have got one judgment, and still 30 lakhs, my lord, has remained unpaid. And your lordship may kindly see Exhibit 9, what has been exhibited by the prosecution in the case. My learned friend highlighted the examination in chief, and your lordship may kindly see if the LCR is there, I may be permitted to
what
place.
he says is the illegal notice was issued to director,
Director,
the Purushottam Engineering and United.
Your lordship, may kindly see the address.
Not happily worded doesn't mean that the notice is not sufficient.
No, your lordship, may kindly see the address. IOCL ko pathai.
My lord, your lordship may kindly see.
Thereafter, Paradip, Jagatsinghpur also is there.
Yes.
My lord, my kindly
I director hochandi Bhubaneswar se କହିଛନ୍ତି ତାଙ୍କ cross examination company hochi Katak se kintu pathaiଛନ୍ତି Paradip jani.
No, my lord, your lordship may kindly see
Complaint,
Exhibit
show me
8.
the complaint.
My lord, may kindly see the document which has been exhibited from the side of the prosecution that has been marked as Exhibit 8. On joint venture, your lordship, a certified copy was exhibited during course of the trial. On joint venture, this document was exhibited. Your lordship may kindly the recital of this document which speaks that in which way I was paying money to him, and just 1 year prior to filing of this case, this document was registered. And the certified copy has been exhibited. Your lordship may kindly see Purushottam.
Is a clear-cut case of cheating. You should have prosecuted him for cheating. You should have prosecuted for him cheating.
My lord,
And two persons were made.
Complaint petition is under Annex 2, my lord.
And my lord,
Annex 2. Yes.
No. Annex 2 is the judgment.
In my petition, where Saroj Kumar Pusti is the petitioner. He
No, there only I am
796. 796.
same thing I am looking at that only. Annex 2 is the judgment. Saroj Kumar Manti?
नहीं आर फाइल टा
Saroj Kumar Pusti.
आ गया.
Okay. Annex huh?
नहीं это judgment.
No,
Judgment. My lord.
What is the check amount?
8,50,000, madam.
How much he has deposited?
1,50,000 in the interim application by here deposited 1 lakh.
Appellate stage.
At the time of admission of the case by
Admission of which case?
This present case. Your lordship may kindly see the entire examination in chief as well as cross examination. The conduct of the accused will be apparent. And it is his case that 25 lakhs he has paid and the rest of the amount has remained unpaid.
Actually, the complaint also, that's the very faulty way of drafting what. You say that intentionally avoided to receive the legal notice, and the same notice was returned without service.
My lord, what I beg to submit in IOCL para.
Was it necessary to write in the complaint?
My lord,
You create a problem for yourself by writing. The onus has gone to your
My
head.
lord,
Now to prove that it is.
what has happened, your lordship, with the document?
Generally, with due respect, generally what I used to do in my
Yes,
thing,
sir.
I used to write, it was sent, and that after receiving, he telephoned me and promised me to pay, thereafter he didn't pay. So service is proved, everything is proved, everything goes to his
But
head.
here also the complaint.
That is neither here nor there, but you write in the pleading.
Here
That is the way you should have done. And you said that it returned back. Then the onus is on your head because it's a statutory notice.
My lord, statutory, my lord, your lordship may exhibit 8, which I passed it over to your lordship. In that document, your lordship will see that is the head office address.
The language is you have to serve a notice.
My lord,
38.
both the addresses
Service
are.
was in your head.
My
And
lord,
you yourself say that service could not be complete.
your lordship may kindly say that notice has remained unserved only because
Because it's not important. What is the requirement of law?
My lord, it should be properly addressed. And
Not addressed. What is the language?
Sir.
AC 130. It should be served.
My lord, if it is properly,
notice and
with due respect, your lordship, if it is properly addressed and notice has gone, registered notice has gone, and for some other reason, your lordship knows in which way the accused persons are manipulating for getting back the notices
all
returned.
these things will not work, sir, because the statutory requirement is notice has to be served.
My lord, if
And you yourself writing in the complaint that it could not be served.
and it has remained unserved, your lordship.
That is the problem.
Due to willful refusal, it may not be refusal, but willful avoidance of receipt of the notice, because in correct address it was sent.
नहीं लिखा है address is not found. ताले correct address केमती गला?
Address is not found.
नहीं wait a minute.
Very difficult.
But with due respect, my lord, I could not, now I am able to install, but there is a decision of honorable appellate, my lord.
Was not there. The parties are directed to file the additional documents.
At 2 PM it also, ma'am.
Additional document, you file the additional document.
Your lordship, kindly allow my eye.
Yes, I don't have any objection.
Item 3.
Perhaps Mr. Alfred was held up in some other court lordship. When I was there in the court, he was held up. Another item is there when Mr. Mahanti is appearing. It's Okay. item number 2 that we lordship. can take up. Yes.
Two will take it.
Yes.
He is alive.
Yes, sir. It's very much. Lordship, the appellant has preferred this appeal against order of conviction for alleged offence under section 13(1)(d), 13(2) and section 7 of the PC Act, sentencing him to undergo imprisonment for 1 year and to pay a fine of ₹1,000 in default of RI for 3 months more for the offence under section 13(1)(d), read with 13(2) of the PC Act. Lordship, the plea of the appellant was that of denial, Lordship. Lordship, in order to substantiate this case, the prosecution examined 8 witnesses, Lordship.
Yes.
And from the defense side, 1 witness was examined, Lordship. Lordship, may kindly have a glance at PW1, Lordship. That is at page 46.
46. Paper there?
Yes, paper 7. Lordship, the allegation is that the present petition or the present appellant has demanded a bribe money of ₹250 from the complainant, that is PW5, Lordship. Lordship, PW1 is the accompanying witness. He accompanied the decoy, Lordship. Lordship, can you have a glance? He happens to be the overhearing witness. He happens to be the overhearing witness and present at the spot, Lordship. Lordship, can you glance at page 48, Lordship?
48.
He has been declared hostile. And he has categorically stated that the presence of Hon'Ble
He was there in the room of the accused, lordship, the present appellant. But the Amin was not charge sheeted witness. Rather, he was a defense witness who has categorically stated the amount was paid for measurement of the plot. That was the official fees, and it has been duly corroborated by other witnesses, lordship.
250 rupees, this is officially.
No, 220 rupees was the official cost, lordship. 250 rupees was paid, and at the time the vigilance team entered, the PW1 has categorically stated that the receipt book, the Amin has the present RI had called the Amin to get the receipt book so that he could give the receipts. But at that time, the vigilance tapped him court hold up, lordship. Lordship, it has been categorically stated in page 48, lordship.
48, yes. He has been declared hostile, huh?
Yes, my lord.
Yes, lordship.
Yes. What does he say? Where?
In para 3, lordship.
Hmm? Hmm.
Lordship, 1, 2, 3, 4, 5,
Yes.
6, 7, 8, 9, 10, 11, 12, 13. Lordship, 20th line. The office of RI has only one room.
Which line?
20th line. 2, 3, 4, 5,
The office of RI
has only one room with a front veranda. There were tables, chairs, and benches kept in that office. One Amin was present in the office of RI with him. After the arrival, his office, some outsider also came to him. There were 3 to 4 in number. The Amin who had come with the RI to their office was going to issue receipt to the decoy by bringing the receipt book from Almira. Just at that time, the vigilance raiding party members dusted. The present Amin was never cited a witness by the prosecution, lordship. Rather, he was cited as a defense witness, and he was DW1, lordship.
He also says the same thing.
Yes, sir, lordship. That is DW1, lordship, at page 29.
Page 84.
Page 81.
84.
But in my paperwork, it's 81.
It starts from 81, yes.
81
minutes.
81, lordship.
Yes. DW.
On 2/11/1991, the para 2, lordship.
The RI accused.
Amin, lordship. He's the Amin.
RI accused.
Yes, sir. The RI accused at about 7 to 8 a.m. set out from our office together with official records for collection of revenue. We met one Prafula Patel on the way at the entrance. He asked the RI as to why he has not submitted his report in mutation case filed by his father. The RI replied that he had not deposited a demarcation fee at the rate of 4 rupees per plot. Total plot number of plots is, lordship, 55, lordship. Altogether coming to 220 for 58 plots, to which the land to be demarcated was consisted of. Hearing this, Prafula Patel got angry with the accused and he went away telling that he would see him. Then we went for collection of the revenue and returned about 6 p.m. Of the said day. On our return, I found Prafula Patel accompanied by another. Prafula Patel called the accused and offered the demarcation fee as in my presence. Then the accused went inside the office followed by me. Prafula Patel entered the room thereafter. Prafula Patel made over 250 in the shape of 50 rupees GC notes. The accused RI kept the said money on his table and told me to bring the receipt book, mutation case record, and also issue receipts in support of the payment of demarcation fee. Accordingly, I brought the receipt book and 3 mutation application. While I was about to issue receipts to the complainant by setting carbon, the raiding party entered our office, caught hold of the hands of the accused, giving their identity to him, and told me not to issue the receipt to the complainant. Then they challenged the accused RI to have taken bribe from the complainant, to which he denied and stated instead that the complainant paid him a sum of rupees 250 towards demarcation fee of 55 plots, in respect of which mutation application put in by his father, for which he told his Mohri to grant the receipt in support of the said amount and to return the balance of 30 rupees. The vigilance raiding party seized the receipt book and also the money of 250.
Yes.
Lordship.
Lordships, all the
So
witnesses.
PW1, huh?
Yes, Your Lordship.
PW1 and DW1.
Yes, Your Lordship.
PW1 and DW1 have the same version.
Yes, Your Lordship. And all of the witnesses have categorically stated regarding the presence of this DW1 witness, the Amin, in the present room.
I mean, while entering into the witness box, you were still in service.
Lordship, I was not
Or
aware of
retired.
that.
Read it.
But he was not added.
I
as a-
was, my lords. I was at Lida's collection morir attached to RI office. Because the
And
strap
they
was
all
on,
were performing their official duty, Lordship.
That's right.
the strap was on 2/11/91 and this evidence has been recorded in 97.
By the time you had already retired. Yes, what else?
Lordship, evidence of PW5, the decoy, Lordship.
PW5.
Yes, Your Lordship.
Page 59.
Page 59, Lordship.
Yes.
Lordship, in page 61, one lady constable was with them. She has not been added as a witness also. He was accompanying the trap team. If there were discrepancy, she could have easily been added as a witness, Lordship.
That is not certain. They may examine, they may not. examine.
Lordship, at page 64, page 63, first Lordship. I scribed the FR all by myself without anybody's instruction. 63.
Yes.
For the cross-examination.
Huh?
Lordship, he is the scribe of the FR, Lordship.
I do not remember to have made which one? Cross-examination.
Yes, Lordship.
I scribed the FIR. I
He
scribed
is the
the FIR.
scribe of the FR, Lordship. And in page 64, this decoy witness has categorically stated regarding the presence of DW1, Lordship. In page 64,
No,
second
if
line.
he is a scribe, what do you want to say?
Lordship, scribe, he very well remembers all the facts of the case, but he hasn't mentioned anything regarding the presence of this witness, DW1, the Amin. Lordship, at any frag of imagination, suppose a person is going to take bribe. Why will he take in front of others? Unknown person, Lordship. Lordship, in page 64. Second line, we waited there for 10 to 15 minutes. As the office was closed, the accused RI and his collection Mohrid Bhimsen Sahu came together to the office from the residence of RI. Bhimsen Sahu was working as Patwari also. Accused RI opened the door of his office and entered first, inside with Bhimsen Sahu. We followed. At the time, there was no electric light in that office. It is not a fact that the accused RI, after taking the tented money from me, keeping on his table, and asked Bhimsen Sahu to bring the receipt book.
Not a fact.
Not a fact, Lordship. But all of them, the money.
This is the DW1, Bhimsen.
Yes, Lordship. Lordship, it is the money was collected from the PW5 and was kept on the table. And even the receipt book was also seized, Lordship.
The receipt book was seized by the IO.
Yes, Lordship. And Lordship, another point, another ground is that the sanction was defective in nature, Lordship.
Where was this receipt book found?
On a table, from the hands of the Amin only. He went to the Almira and collected. He has categorically stated. On my instruction of the appellant, he went and got the receipt book from the Almira. In the cross, he has categorically stated, Lordship.
Is it part of seizure list?
Yes, Lordship. At Exhibit 14, Lordship.
Yes,
Part
ma'am.
of- Yes.
And the trap has happened in the office, so all these materials are bound to be there. So seizure of, my lord, that receipt is of no help to the defense as far as my humble
But
submission is
the
concerned.
defense
My lord,
which is
DW1,
putting
yes, my lord, DW1 in my humble submission is a got up witness. Your Lordship may kindly come to DW1, page 84.
Here.
Page 84. The last paragraph, this is in cross methods. I'm relying on cross.
I'm not, it is not effective.
Yes, my lords. It is not a fact that the IRI told me to issue receipts in support of payment of demarcation fee of rupees 220 by the complainant in the evening of 2/11/91. It is a fact that it is for the first time I am giving the statement in the court that the accused RI told me to issue receipt to the complainant in support of payment of 220 as demarcation fee, and that I could not issue the said receipt as the IO sees the same. This is the first time he is deposing in the court, not even during the trap or in the detection report, nor this thing has been intimated to the higher authority.
But his presence is doubted.
Presence is very much there.
Then you should have cited him as a witness.
Yes,
You have
Lord.
not cited.
No. Presence
Then obviously where he will go and tell? Either the police, if you
Unless
have
he has been
cited,
examined.
the police has not examined. So therefore, the first available opportunity is to come to the court and tell.
Well, in detection report also, he is a signatory in the detection report. If I'm not wrong, he's there.
So then what are you trying to get out of it? Yes, first time.
He has
obviously.
first time, yes. That's what I'm saying, my lord.
And before that, where was the occasion?
He
for it?
was, he didn't have any opportunity.
He
Lord.
would have informed the seniors about it, or during the time of detection also, my lords, he could have said this to the raiding party.
To whom?
To the police concerned, my lords.
At the raiding party. See,
Yes.
161 statements are recorded in which way you know that.
Then, my lords, no suggestions have been given to the IO also regarding this thing, my lord, that he did not allow the DW1 to issue the receipt. This is the defense that has been taken. And if your lordship may kindly come to PW8 witness, my lords may kindly come to PW8.
PW8.
Yes.
Okay. Yes.
Page 73, my lords. Page 73 onwards.
He's the dacoit.
No, man. He is the IO.
IO.
IO. My lord, they say that he was the police, the vigilance police did not allow them to issue the receipt, and that was taken away by them. But this has never been given in any suggestion to in the entire deposition. No suggestion to that effect. That this particular person has snatched away the receipt and seized it, and he did not allow the to issue the receipts. No suggestions, my lords, nowhere.
Lordship, PW1 may have turned hostile, but some part of the evidence should be taken into consideration, Lordship. He categorically states that the Amin was about to issue the receipt, Lordship.
But he has been declared hostile.
Hostile, but recently
That's
the
okay.
Apex Court has stated.
Not recently, it is there. It is there. I do admit that. You have to separate the grains or shafts from the grain.
Yes.
Where the money was found in the table.
On the
On
table,
the
Lordship.
And lords, money was found on the table. They says that this money was taken for the purpose of demarcation.
Demarcation.
But why has he kept it in the table?
That's I'm explaining that. They said that they have taken this money for the purpose of demarcation of 55 plots at the rate of ₹4 for each plot.
And it has been corroborated
Just
by
a
other
minute, Mr.
witnesses.
Maran, just a minute. And if 55 plots were to be demarcated at the rate of ₹4 per plot, it comes to 220 rupees.
So he says that 30 rupees I was there.
Was to be returned, Lordship.
That
And
is
the
after
presence
the
of-
trap one, Lord. This has been made. This is a made up story this is a defense, my lords. Instead of 220, 250 was accepted, and the entire chemical wash.
I want 50 rupees more.
30 rupees more. And
50 rupees no.
50
rupees note. And my lords, the entire chemical wash was positive all through.
That's there. He says.
Acceptance is very much there.
Where is the demand? Where is the demand?
Demand, your lords. Lordship, kindly come to page 59, the demand part. The decoy, what the decoy says.
59.
Yes. The first paragraph. What you got it, maths?
Yes.
From below, 6th line, my lords. The accused RI demanded a bribe of ₹1,000 to do our work, stating as it would take a lot of time for him. Then your lordship may come to page 61.
No, no, read full.
Ma'am,
Express.
I expressed my inability to pay such a big amount. On 1/11/91, I went to the accused RI for the second time and requested him to do our work. Now, ma'am, the demand was scaled down to rupees 600.
600.
I agreed to pay rupees 250 the following day. On 2/11/91, this is the date of trap, my lords, came to the office, SP Vigilance, and then there was demonstration, all those things.
Lordship,
The lordship may kindly come to page 61. The incidents, my lords. Narration of the incidents. Page 61 in the middle. The sentence beginning with, we met the accused.
Yes, we met the accused
Yes,
RI.
we met the accused RI in his office. At my site, he asked me whether I had brought the money as per our earlier bargain. This is the demand part. To his query, I introduced Sri Carlo as my relation. I handed over the tainted money to the accused RI on his demand. He counted the money and kept the same on his table under a paperweight glass. Soon thereafter, the raiding party members rushed inside the office of accused. The vigilance police officers introduced all of us to the accused. One vigilance police officer caught the wrist of the accused. He challenged the accused to have received bribe from me. The accused became nervous and could not speak anything. His
Where
palms-
does he say that he has paid the demarcation fees?
No, wherein lordship, the debate is 600 rupees as per the witness.
No,
that was
Has he said anywhere that I have already paid demarcation fees? He is asking for demarcation.
Yes.
And it is undisputed that for demarcation 55 rupees per
plot.
demarcation.
4
And
rupees
it-
per plot.
4
rupees per plot into
it comes
55.
to 220.
30.
30.
20, sorry.
20 or 220. Has he said that I have already paid this and thereafter demarcation is asking?
No,
for
that has not been, because he was going to this accused for the purpose of demarcation only.
He has to say that I have already paid that. Over and above 250, he has to pay the amount of 600.
My lords, 250 is to be paid after demarcation. If your lordship may come to the witness
Show
of
me after
PW3, who is the
After
senior
demarcation
clerk.
or before demarcation?
My lords, PW3 is the senior clerk who is dealing with these mutation cases. Now, what is the modus operandi? Your lordship may kindly come to page 55.
55.
Yes.
Yes.
55. This is in the cross.
Yes.
Presently on transfer, I am working in Collectorate Hon'Ble. The seized records are in Rengali Tehsil office. I worked at Rengali Tehsil office for 4 years in the mutation section. I was also working in other sections. If a party makes application for
55
mutation.
you are reading, na?
Yes, my lords. The cross-examination part.
Para 2.
I'm just placing 1 second.
Yes.
Presently on transfer, I am working in Collectorate Sambalpur.
Yes, I read it.
My lords. The seized
The
records are in
demarcation
Rengali
is
Tehsil office.
collected.
I worked at Rengali Tehsil office for 4 years in the mutation section. I was also working in other sections. Now, here he says the modus operandi. If a party makes application for mutation of his land, the Tehsildar concerned asks the RI to furnish a report. The RIs in some cases used to collect demarcation fees and then furnish a report to the Tehsildar. And sometimes the demarcation fee is collected at the time of finalization of the mutation proceedings. And there are 2 ways, either before or after. So in this case, my lords, the scheme was like this. First, he will demarcate, and then the fees is to be paid to the treasury.
But where is the bar that he can't pay earlier?
Beforehand also, lordship, they can pay. He has categorically
In both ways,
stated.
my lord. They can pay even
advance,
before or after.
Can you get anything from anywhere to show that over and above the demarcation fee, the money was deposited or demanded?
Well, it's 250 he asked instead of 230, because
But demand was
55, just a minute. 55 plots were to be demarcated at the rate of rupees 4. That comes to 220 rupees. Demand was made of 250 rupees, my lords. So 250 was paid, and during the trap, 250.
The bribe money is 30 rupees according to
No, my lords, 250 rupees. 250 rupees is the bribe money.
220 you deduct.
That's why I want to substantiate that this is not for demarcation. This is entirely the bribe money, not for the demarcation purpose.
Lordship, I would rely on 2 judgments of the Supreme Court, Lordship.
Who is
And my lord, when a sanctioning authority is at PW6.
PW6. And
my lord, he has accorded the sanction. My lord, after going all through the police papers and all the documents present at the relevant time, Now he came to a conclusion that criminal law is set to be set into motion for this accused. Now he has ample knowledge of the department how it works, my lordship may kindly consider that.
You need not say anything for sanction. The post itself is enough. RI means RI means and all the you know.
In that case, my lord, I rest my case.
Lordship and
RI means
Lordship
they can write a plot of
Yes.
the moon also they can write in your name.
Yes.
If you pay them.
Lordship in page 68, in the cross-examination of the sanction.
And my lords, that apart, my lords, PW5 was never put any suggestion regarding return of that 30 rupees. If at all they say that they have paid this purposefully for the purpose of demarcation at the rupees 4 for 55 plots, that comes to 220 rupees. So 30 rupees is to be returned. No suggestion was nowhere put to the PW5 to the decoy. Have that been the case, they should have put a suggestion to the PW5. That has never been put up.
Lordship, it has been corroborated by PW1, but he turned to be hostile on that aspect, Lordship.
Well, PW1, where does it?
Well, as PW1 happens to be the overhearing witness. The
And he just read that.
suggestion is to be put to the decoy, my lord.
30 rupees.
He accompanied the decoy into the inside that room, Lordship.
About 30 rupees he says or anything.
Well, nowhere, no suggestion was put to the decoy. He happens to be the principal man concerned with the entire transaction.
The Lordship, it starts with the Amin who had come with the RI to their office was going to issue receipt. Lordship, why will a person issue receipt?
That's there, but 30 rupees. He's talking about 30 rupees.
Yes, my lords. Why no suggestions were put, my
somewhere
lords?
to find out that
No suggestions
you're
were
ready
put,
with
my
the
lords.
30 rupees to return.
My lord,
something.
I have
Lordship-
scanned the entire document on this aspect
Before
because
he
my
take
case
it-
rests on this rupees 30. So I have seen, my lord, no suggestion was put to the decoy.
Lordship,
And no suggestion was put to the IO also that he did not allow the Amin to issue the receipt and he has seized without that. Receipt was seized, but no suggestion was put to the IO that at the time he was just about to issue the receipt that has been seized. No suggestion to that effect also.
Let us see IO.
Well, PW8, page 75. Nowhere, man.
Lordship in page 79, Lordship. Second line, one Bhimsen of a collection Morir also found present along with the complainant and accompanying witness in the RI's room. He was examined but not cited as a witness. I cannot say when the demarcation fee was paid by the petitioner in the mutation proceedings. I have examined the Tahsildar Rengali Tahsil. Tahsildar has stated before me that the demarcation fee for the plot to be mutated is to be paid to the Tahsildar or to the RI at any stage of the proceeding. In his subsequent statement, the Tahsildar has stated that the demarcation fee is to be collected before measurement of the plots applied for mutation as per mutation manual. Since 1980, rupees 4 for each plot is being collected from the applicants. Exhibit 14 is the receipt book sealed by me from the accused. Exhibit 14 containing the receipt shows collection of demarcation fees in mutation cases other than the pending cases of the complainant, Lordship.
Where is that, my lords? That he has snatched it from the RI Amin and he did not allow to issue the receipt. No suggestion to that effect. My lords, this DW1 in my humble submission is a got up witness.
Lordship in page 68, the sanctioning authorities cross-examination.
1 minute, and just IO I'm reading. the IO page 78, come to 78. He says that he received the bribe amount of 250 rupees, counted it, and kept it on the table pressed by the paperweight.
My lord, sir,
If it was meant for bribe, he would have put it in the pocket.
or
Why should
inside
he keep it in the put
table.
the paperweight there? That paperweight then he should receive. That was the idea.
my lords, the defense have two important points in my humble submission. One is regarding the receipt. That
I am only examining that part. I'm trying to find out how to get out of it.
Lordship, it is
What is the behavior, human behavior? If bribe money is given,
in
he
that
counts.
case-
The
Yes.
important thing is he counts.
Yes.
If he would not have counted, it's something different. He counts the money. Once it is bribe money, immediately he'll put it in his pocket.
Pockets or drawers, some.
After having counted, there is no point keeping it in the table and put the paperweight on over that.
My lords, as far as his conduct is concerned, my lords, there are evidence that he initially fumbled. That is also there. If your lords, if
he must be a corrupt officer.
Yes.
He might have been fumbled. That's not the issue. The
Yes.
issue is from the evidence, how will you convict him?
Well,
And we are trying to find out ways to acquit him. Okay.
So that's-
therefore,
that
we read the evidence in that fashion. How we can exchange the benefit of the.
And,
You are right, absolutely right.
well, there are two things on which the entire defense case rests. One is the receipt and the amount. In both things, they have failed to establish because no suggestions were put to the PW8, who happens to be the IO, that he snatched away the receipt from the Amin, did not allow him to issue the receipts. Secondly, they say the money was paid towards demarcation of plots. So 200 at the rate of ₹4 for 55 plots, it's come to 220. 30 rupees was residue. And my lord, this suggestion was also not put to the decoy. That you have paid 220 rupees and he was about to give you back.
What
30
does the decoy say? It is recovered from where? Pocket?
Page 59, your lordship.
He categorically states that it was on the table. He kept it on the table.
59, your lordship.
Copy of requisition.
Page 61 in the incidents, my lord. He handed over the money to the accused RI on his demand. He counted the money and he kept the same on his table under the paper. The accused accepted,
Page
counted,
61.
and then he kept it on the table. It was the accused who has kept malice.
Lordship, it starts with, I handed over the tainted money to the accused RI on his demand. He counted the money and kept the same on his table.
That day, the decoy had gone only to pay the bribe money.
Yes, that was the date of trap fixed and he was called on that date to pay the bribe.
Only bribe money.
Right. And then your lordship may kindly come the subsequent
are you
lines.
sure that he has gone only to pay the bribe money or?
Lordship, initially he states
Yes, my
600
lords.
rupees was
Because
demanded.
in the FIR, my lords, it has been written there that on
No,
211.
that context you read IO. IO here says.
Well, because the contents of the FIR at Exhibit
No,
10.
I just say page 76, last 3 lines.
Well,
Read that. IO says, I also seized 8 numbers of mutation application,
Whatever-
or carbon copies, filed by the complainant from the accused along with the documents. He had gone with the mutation application.
Yes.
Along with 250 rupees.
My lords, the arrangement was such. You pay me.
No,
and
don't analyze.
My
You
lords.
tell from the evidence. It was seized. That means the mutation application was also given on that day. Mutation application along with the fee.
Yes, Lord.
Which was seized. Both the things were seized from his position.
Filed by, my lords, may kindly please see that same line. I also seized 8 numbers of mutation applications. All are carbon copies. Now, that means that was kept with the in the possession of the accused, because these are all carbon copies, my lords.
No.
Filed by the complainant from the accused. It was in the possession of the accused, my lords. From there, it was seized.
After receiving the fees only, they would do the
Well, it's like
demarcation.
this. Because these are all carbon copies, my lord. These are not original. Had the accused taken all these applications, it would have been in the original format, not in the carbon copies. And it has been seized from the accused, my lord, not from the complainant.
That's what I was wondering, why it was there with him.
Because, my lord, he was dealing with so many papers. And he was dealing with mutation cases, my lords. So that was there on the table. And the arrangement was such, you pay me the bribe, then I will process your file. And those things were lying on that table.
Lordship, suppose the case of the prosecution is to be accepted. Initially, the demand was 600. How come without any meeting of mind, it came to 250 rupees?
Well, that apart, once the money has been accepted, my lords, money has been accepted by the accused, he has admitted, my lords. Once it has been accepted, section 20, my lords, comes into foreplay, my lords, of the presumption, my lords. My lords, the accused has to dispel the onus under section 20 of the Act with plausible reasons, my lords. And the reasons that he has given does not stand under close judicial scrutiny.
Lordship, to that contention,
Read para 6 of IO, 16 cross-examination.
My lords, para 6 or 16? My lords?
16.
1/6.
1/6. 79, page 20.
Page 80 minutes.
No, 71.
79, yes.
79, Lordship.
19.
My lord.
79.
79, para 16.
Uh.
So as stated before me, the demarcation fee for the plot to be materials to be paid to Tehsildar. What is the RA at any stage of proceeding? In his subsequent statement, Tehsildar has stated the demarcation fees to be collected before measurement of the plot apply condition as per mutation manual. Hello, this is the procedure notes. Since 1980, rupees 4 for each plot is being collected from the applicants. Exhibit 14 is the receipt book seized by me from the accused. Exhibit 14 containing receipt shows collection of demarcation fees in mutation cases other than the pending cases of the complainant.
Yes. Anything else?
Lordship, to that aspect, in the cross-examination of PW5, Lordship, I would like to state, suppose the demand was 600 and there was no meeting between both the parties. Subsequently, how come it came down to 250 rupees, Lordship? Initially, it was 1000. Subsequently, it came to 600. Now it came to 250. In his cross, he has categorically.
He says that 600 was demanded and thereafter he agreed for.
Initially, 1000 rupees was demanded. Subsequently, it came to 600.
That is the specific deposition of the PW5.
He reduced in page 59. Lordship,
Page
the
59.
accused RI demanded a bribe of 1000 to do the work, stating as it would take a lot of time for him. I expressed the inability to pay such a big amount.
That is the reason it was scaled down.
Lordship, on 1/11/1991, I went to the accused RI for second time and requested him to do our work. He reduced his demand to 600 rupees. I agreed to pay 250 following the following day. On 2/11/91, I came to the office of SP Vigilance Sambalpur and lodged a written report. I scribed and signed report marked Exhibit 10 with my signature.
Plus, the deposition of PW5
And
fully corroborates with the FIR at Exhibit 10, my lords.
And
That is-
it- and
and the FIR is
16.
totally.
No, see, 59 if you see,
My lords.
on 1/11/1991,
Yes, my lords.
I went to the accused RI
Yes.
for the record, second time.
Yes.
For the second time. He requested him to do the work. He reduced his demand to
600.
600 rupees.
Okay. His demand was 600.
Yes. Thereafter,
And erase there, no problem.
Yes.
Thereafter, what he sees,
I
I
agreed-
agreed to pay 250.
yes. Because that was initial demand was 1000, that was scaled down to 600, then 250, my lords.
The
Because
then-
before that, my lords,
then the complainant
my lords.
himself decides that I'll pay
250 rupees.
Why, my lords? The pre.
I'm not on why. I'm on
My
the
lords, it's there.
language.
I'm on this land, my lords. Lordship may kindly.
Only to justify the 250 rupees which you have taken for the purpose of paying fee, he's saying that I have reduced myself to 250.
My lords, just before that he says.
I can understand 50 rupees. Where is the question? Somebody is asking 1,000. He says, give me 600 rupees.
Suddenly.
But I decided that I'll give it 250.
So why I decided, my lord?
It's there, my lord. He has agreed for 250.
It's there, my lord. If your lordship may kindly, I will
Where
just.
does he say that I am agreed for 250?
My lord, may I just repeat those lines once again, my lord?
Yeah,
Subject to your lordship's approval, my lord.
Why has he reduced
Same line, same
Yes,
same
great.
paragraph.
Definitely.
The accused RI demanded a bribe of rupees 1,000 to do the 2-hour work, stating as it would take a lot of time for him. I expressed my inability to pay such a big amount. My lord, that is where I am thirsting
So
upon.
therefore, you reduce down to exact 250.
From 600 to.
I can understand 300. What is the genuineness of 250? Because it matches with the recovery.
Well, it doesn't matches with the recovery, my lord,
Lordship
because that
matches
30
with the
rupees is
fee.
30 rupees is still deficit. It is still more, my lord.
Lordship in
Had it been 220, my lords, I would not have any case. And thereafter, my lords, the entire defense plea that they have taken, no suggestions have been put regarding receipt.
Sir, it creates a lot of doubts.
Lordship in page 62. In the examination, 4th line from the bottom. I bought rupees 350 with me when I attended the preparation for the trap. If a person doesn't have ability to pay, why will he get 350 rupees? And only 250 was fixed.
Page 62. Last time. I bought 350 with me when I attended the preparation for the trap. At 10 a.m.,
page 62,
I reached the vigilance office,
62,
Sambalpur, and so and so, not related to me. If he was agreeing for 250,
I'm just not able to get that line.
page 62.
My lords.
Page 62.
Last 3 lines.
I bought rupees 350. I bought rupees 350 with me.
My lords, I got it. My lords. I bought rupees 350 with me when I attend the preparation.
He decided that I'll give only 250, but he comes with 350 and to the vigilance office.
My lords, he may be having
for the purpose of preparation for trap.
My lords, there is nothing in the manual that the person who comes to lodge an affair or for a demonstration, he has to bring the exact amount, my lords.
See the sequence.
Even 250, my lords, he may be having
why has he
500 also, my
he
lords.
doesn't have the money.
So, my lords,
why has he got with 350? How will
there is with my humble submission, there is no embargo that a person coming for a demonstration, he will bring the exact amount of trap money.
We have to test.
He maybe have excess money also.
We have to test the defense.
My lords.
In the light of the evidence of the
yes.
Yes. So, witness. Particularly when the defense in 313 takes a defense and examine a witness who is a genuine witness who was present. Presence is not doubtful.
Yes.
He was a government employee. Then in that context, you have to see.
My lords, here acceptance is not disputed, my lords. One, acceptance is proven, my lords. Section 20 lordship knows comes into play. And he has to dispel and discharge the onus of section 20 presumption.
No, you show me any judgment where even if acceptance and he has to show me rather, even acceptance and demand and acceptance is proved.
Yes.
Even then, if there is a doubt on the prosecution story in any count, the benefit of doubt can also be given.
Lords, I will be relying
despite the fact that demand and acceptance is proved. In this case, demand and acceptance is proved.
Yes, my lords.
But that demand is vis-a-vis what? That fee.
Whether for illegal gratification or
for defense plea that they have taken, that doesn't stand itself, my lords. They are not able to prove their own case. The defense is regarding receipt.
Come to your 313. What is?
Yes, my lords. Page 41 onwards, my lords. 313 statement, 41 onwards.
Yes, question number 10.
10, lordship. The complainant, the question is transferred from the evidence of PW1 and 5 that as per instruction given to them, they went to our office. PW5 entered into our office along with PW1. whom was introduced to you as his relation. Then you ask the complainant if he had brought the money as per your earlier bargain. Accordingly, he handed over the tented money to you on your demand. You counted the tented money and kept the same on your table under a paperweight. Soon thereafter, PW1 gave pre-arranged signal to the raiding party, who rushed immediately inside your office. What have you got to say? The complainant paid the amount towards fee of demarcation in 8 mutation cases in respect of 55 plots.
Well, this is their defense, my lords, that there has been taken from the very beginning.
Specific defense taken, defense evidence laid. 17, question 17.
Question 17, Lordship. After hearing the entire evidence of the prosecution witness, what more have you got to say? The complainant has encroached a government land. When I objected to it, he came along, he became revengeful. So he foisted this false case.
Against
him.
Against him. He paid me rupees 250 towards demarcation fee. At the time, Bhimsen Sao collection Muhri was in my office. I told him to issue receipt of rupees 220, Lordship.
Okay.
But before the said receipt was issued, was caught by the raiding party.
There's no suggestion to this effect to the PW8, the IO. And when what he has said that a complainant has encroached a government land, this was also never put in the suggestion methods.
It was put to PW5.
Whereas how will he dispel the onus of section 20 of the presumption methods of the Act? That should be plausible and reasonable methods. The defense plea, what he is taken, his fails to stand, it gets demolished totally.
To that aspect, I will cite the decision of the Hon'Ble Apex Court, reported in 2014, volume 13, SCC, page 55. Lordship. It starts with the public accountability. Section 7, 13, D1 and 2, and Section 20, conviction under reversal of as demand of illegal gratification not proved. Appellant accused, prosecuted based on complaint exhibit P13, lost by complainant. Though PW2 later turned hostile, trial court convicted the appellant based on the evidence of punch witnesses and recovery of tented currency notes from appellant accused. Untenability. Held, complainant PW2 turned hostile. No other witnesses present at the time of transaction between PW2 and the appellant accused were examined. When PW2 discovered his own statement, the contents of complaint exhibit P11 cannot be relied on. In absence of proof of demand for illegal gratification, mere recovery of tented currency notes from the appellant accused did not establish commission of offense. So the demand of illegal gratification by the appellant accused not proved beyond reasonable doubt. Hence, conviction of the appellant accused set aside. In Placitum B, Lordship. Public accountability. Section 7 and 13, D1 and 2. Preconditions for constitution of offense thereunder. Reiterated. Held, it has to be proved beyond reasonable doubt that the accused voluntarily accepted money knowing it to be bribe. In absence of proof of demand for illegal gratification or use.
Where are you reading?
Lordship, I've cited the judgment.
I'm still in the evidence.
Sorry.
I'm struggling to find out.
Lordship, this judgment squarely covers in my case.
And these see PW5 suggestions were put in the regarding this defense. Specific suggestions. 65. And the last couple of lines. Specific suggestions. Exact same defense was taken. And this suggestion and thereafter the 313 and DW.
No, this defense they have been taken consistently. My lords, may kindly have
Consistent defense.
one judgment I am
It's not that all of a sudden after all the evidences are taken, they're cooked up a defense and then put forth. That's not the case.
Lordship, kindly say, I'm just relying on one judgment, my lords.
Yes.
Reported in AIR 2023 Supreme Court 4739. P.
What is the
Sarangamani
proposition?
led through LR Paka Saroja versus State of Andhra Pradesh.
What is the proposition?
This is about my lords, presumption.
Para?
Presumption. Last page, my lords, page 4743, para 12. In the Lordship, have it, my lords?
In the instant case.
Lordship, have it, my lords?
Yes, in
the instant case, the pre-trap and post-trap proceedings were duly proved by the prosecution by examining the concerned witnesses who had duly supported the case of prosecution. Both the courts below have recorded the findings that the prosecution had proved beyond reasonable doubt the conscious acceptance of tainted currency by the accused and also the recovery of tainted currency from the appellant. Therefore, the burden has shifted on the appellant to dispel the statutory presumption under section 20 of the said act.
That burden is only defense.
That burden is defense?
That burden, he is discharging section 20 burden by putting suggestion to the witnesses, by reading his statement under 313 and thereafter leading the evidence. That burden he discharged.
That burden.
That is what we are examining.
But that burden which
is a rebuttable burden. Presumption.
Yes,
how the rebuttable presumption, how will he revert? He revert by way of this suggestion.
How far it is reasonable and plausible, my lords? That lordship has to analyze that.
That is the
that lordship has to analyze it. How far it is plausible and reasonable.
That we have to see the reasonableness of the testimony and whether it coincides with the normal human behavior.
Yes.
Or not, these things we are examining.
Yes, ma'am.
But I'm
obliged.
He is definitely discharging his statutory presumption under 20. I'll tell you, there are many cases where you see there is nothing in 313 statement, no suggestion, straight away DW.
Here also.
But here is a case consistent stand, because in the light of 20, he gives his suggestions to the witnesses. Thereafter 313, thereafter leads evidence.
No, Manoj, what he.
And you don't doubt the DW presence.
Manoj, how he dispels section 20 on two grounds, my lords. With your lordship's due permission, let me place it.
Yes, yes.
One is that the Amin was about to issue the receipts. At the very moment, the vigilance team has a raiding party arrived and have seized the receipt. This was never put suggestions to the PW8. So in my humble submission, my lord, section 20 of the Presumption Act, the first ground which the appellant has taken fades. Because no suggestion was put,
put to
PW8, nowhere was put that he has seized the receipt.
PW5 suggestion.
Well, no, they say that PW8 has seized the receipt books. PW5 has nothing to do with the receipt books. They say that Amin was about to issue.
PW5, the author of the entire prosecution is the PW5.
So what the defense they take is that PW8 has snatched the receipt book from the Amin. He has stopped the Amin from issuing the receipt.
Where is that story? Snatching story has not.
Yes, my lord, it's there. My lord.
Recovery only.
This is what they say, my lord.
Where is the snatching? PW8.
Well. My lords, may kindly come to page 48, the cross-examination of the overhearing witness who has turned hostile.
No, concentrate on 5 and 8.
8, my lords, they say, my lords, it is their defense that the PW8 has snatched away the receipt book. He did not allow the Amin to issue the receipts. But no suggestions was put to PW8 on that score.
That's page 79, exhibit 14.
Rather the IO says that it was seized by me.
Yes, it was seized by me. It was never snatched, or it was never. He has not stopped the Amin from issuing the receipt. Their case is.
IO says that one Bhimsen Sahu, the collector Morir, was also found present along with the complainant.
He was the overhearing witness, man.
So that.
My lords, he is the overhearing witness, my lords. He has to be there.
No, this Bhimsen
Yes,
Sahu.
yes, my lords.
No, what is the name of DW?
PW2, PW1, my lords, page 46.
No, I'm talking about DW.
DW1, Bhimsen Sahu,
DW was Bhimsen. IO says that he was very much present there.
present in the room.
See, page 79.
Lordship,
At the top,
My lords.
I cannot say for how many plot number the mutation proceeding were started. One Bhimsen Sahu,
My lord,
the collection Morier was also found present along with the complainant and the accompanying witnesses in the
Yes.
RI room. He would have been your best witness. You have left him not examining.
My lords.
He uncased the situation and took him as a defense secretary to discharge 20. What else? What else?
How far, my lords, it's acceptable, my lords?
That we
How
have
far
to
it is
check.
acceptable and plausible, my lords? Because in my humble submission, DW1 happens to be a got of witness, my lords. Because
He was your witness. Your IO says that he was very much present there.
present in the room.
And it is, see, the receipt which was recovered.
my lords, this is entire book, my lords.
And he was the right guy for you to be cited as a right witness. You have left him. So the next suggestion, see, I cannot say when the mutation
Demarcation.
demarcation
Fee
fee
of-
was paid by the petitioner or not. This is suggestion to the IO. File a written note.
My
Lordship, to that
Judgment.
aspect, I will cite some of the judgments.
Judgment, you highlight the portion and highlight the portion which I have underlined. If you want, you take it from here, sit down and find out. So that and he has a point that 20.
Lordship, one thing I would like to clarify, Lordship, in that aspect. Suppose two persons are present in the room. Why will I take the bribe in front of them? PW1, who turned hostile, and DW1. Suppose I am taking the bribe money, tainted money. Why will I keep the money on the table? I would have kept in the pocket, or I wouldn't have accepted in front of anyone else. I would have directly accepted from the PW5, Lordship. Why will I take the money in front of others, Lordship?
So who will see DW1 was present in the spot?
PW1 also.
PW1
and
and
PW5.
PW5.
3 persons. were present.
PW1 hostile, DW1 came in your side, and they are relying upon only 5.
5.
5, Lordship.
Who is
Five.
the decoy customer?
Decoy.
He says that demand was 1,000. He reduced down to 600.
Then
But
250.
I thought I will pay to 250.
I agreed to pay 250 because the amount was high.
And
And
then he went with
Because the amount
350.
was high, my lords.
Then he went with 350 to
350 to the.
350, my lord, that is not an embargo that anyone can go for.
Embargo is not.
Suppose the
Mal-
person doesn't have
Credibility-
capacity.
Even
Credibility of a witness has to be tested. His consistency has to be tested. Only on the face of the accepted position that 3 people were there.
That's
Out of them, 2 of them are not with you. Only the decoy customer. And fact that he says that you are the encroacher. So therefore there is a you are taking revenge. If that is the case, then why the other 2 people, those who are independent, not supported you? That's a big question now.
my lords, even if that overhearing witness has stand hostile, in examination in chief, he has said that the powder was dusted with issue notes and given to the decoy for being paid to the accused on demand.
I'm not on that.
But
There was acceptance is proved.
yes,
No doubt about it.
Yes.
Acceptance for what? That's what
Yes,
it
ma'am.
examines.
Yes.
Acceptance, they are also saying that yes, I have accepted,
yes.
but this is for something else.
Whether for illegal gratification or for
But they are not,
demarcation.
when section 20 comes into play, they are not able to give a plausible reason. In
So
my
there
humble
is no,
sub-
there
in-
is no
in-
point. None of us should struggle to establish the fact that whether there was a demand or there was an acceptance. It is proved, no
Yeah.
problem.
Well, in my humble submission, Malas, in this type of exigencies, like when the decoy dies or it becomes hostile, or when the overhearing witness dies or become hostile, then section 20 is that, my lord, that cushion that has kept.
That is why 20 is
20 is
designed.
there, my lord.
20
So
is
now,
designed for that.
now your lordship has to analyze in detail how far they have given plausible and reasonable reasons so that in say 20, how far they have dispelled section 20
No,
presumption.
then insofar as the 20 presumption is there, what best a defense can do, tell me? All suggestions are put in the same line. 313 is said, and thereafter defense with witness, and who yourself say that you were there at the spot.
And my lord, defense they have.
What else
My lord,
for 20?
defense they are saying about the receipts. Those suggestions were never put to PW5. PW8 also they say that receipt was seized by PW8. He did not allow the Amin to issue the receipts. Before that, he has snatched away or taken into his custody.
This is the way the prosecution looks at. The same thing can be looked into in a different way when you change the side.
It's up to your lordship's
Change.
fine sense
But
of justice.
This is
sir.
what we are analyzing.
Yes, my lord.
Give written submission.
Lordship, by next week I will file it.
7 days.
Thank you.